lived here my entire life. My kids are third generation at Eagle Elementary. Just give you a little bit of background. I'm going into my third year on town council. Folks from ZVRA and the Historical Conservation Group in the village came to me first, and we've been working really hard on that with that group for quite a while. So again, I appreciate everybody being here. I want everybody else on the group up here to introduce themselves, and then we can open the door for any questions regarding this specific ordinance. I won't be a jerk about it, but if it's going towards specifically what the village or another area and what their ordinance would look like, I can't answer that today, because that would be something that those folks would work directly with the new commission if approved.
Good evening, everyone. It's my pleasure to be here. My name is Paul Lippens. I'm a urban planner and urban designer. I'm working with the town right now on an update to the zoning ordinance. So my specific role here tonight will be, one, to talk about good planning and design, but also to answer questions that relate to the town's existing zoning regulations and the feedback we've gotten on the new ordinance, which will work in concert with any historic district that were approved. And as the draft says, we'll work with the historic regulations to also regulate residential land uses.
And I'm Mark DeLacy. I work for Indiana Landmarks. We are the statewide historic preservation organization, and I have been advising the town on issues related to this draft of the preservation ordinance as proposed.
My name is Wayne DeLong. I'm the Director of Community and Economic Development of the town of Zionsville.
Thank you, everybody. Like I said last time, just feel free to come on up and state your name and your address and what question you have.
Joe, you sent an email question.
I'm sorry, they're recording this.
Well, actually, the question. Yeah. My name's John Townsend. I live at 305 West Pine Street and been a villager since 1978. Anyway, I sent my questions belatedly, and I was just wondering, is there really any need for me to come up here and ask those same questions, or will you answer those as part of the presentation?
It's either way. I think the four of us had talked about kind of piecemealing this and answering the questions. I assume one of your questions was about the well, you got a lot of questions. The newest one I saw was regarding the timeline for the commission to respond. Is that correct?
Yeah, I was curious that you can create a commission, it can go on forever. So I was concerned about that, and I was wondering whether any timeline would be set on the commission to accomplish the various tasks, or at least an estimate of how much time it would take.
To look at a certificate and approve it, or do you mean like?
No, actually just to, the commission's supposed to do guidelines and a number of other tasks. As you know, I was on the Historic Preservation Committee, and it took us 2 years.
Yeah.
To get to a point where we had the guidelines and everything else. I'm wondering if you have a time frame in mind.
I might throw that over to Mr. DeLacy, who's seen this in other districts, because I don't know. I hate to throw you, maybe someone else can answer.
Well, I mean, I think that it differs in different communities as to how quickly they move along. But, first chore, if this is passed, is for the commission to actually be seated. So the town council and the mayor will work together to find members to appoint. That could be done in as quickly as 60 days, but there's probably a process, a internal vetting process. Then one of the first key steps that the commission looks at is conducting a survey of the properties that are historic, that are here in the entire town limits. So we broaden this out far beyond just the village area. So now I understand that a survey has been started or is in some stage through some folks here in town. I don't know if that's complete.
Yeah, actually, Mark, it's pretty close to, I saw the draft of it today. It's pretty close to completion.
It looks awesome.
Right, yeah. Right. But I just, that would be up to the commission to decide if they want to adopt that as their survey, or if they want to set out to, have a new survey done. If they do, that could take anywhere from 9 months to a year to complete a thorough survey. That survey is then taken to the town council for their adoption. And then the commission works from there to work with particular parts of the community or individual property owners to designate either areas or properties as districts. Each one of those, like let's say there's a district that's interested in designation, the people that live and own property within that area get to participate in a process to create a preservation plan. That plan is what's going to guide the commission in their decisions, and it should guide the property owners in the future into what changes that they are going to propose in making to their properties in the future. If it's just a conservation district, that's just a few things, right? Demolition, new construction, et cetera. It's not physical alterations to the structures unless it's a full historic district. But a preservation plan, doing a public process can take, I don't know, anywhere from 6 months to a year, depending on how long and how large the district is. If it's a single property owner you're dealing with in a single site district, you could probably move it along more quickly than that. And then you bring an ordinance or an application to the commission for what's called certificate of appropriateness. The certificate of appropriateness, when approved by the commission, comes to as an ordinance, comes to the town council as a recommendation for designation of a property that's on the survey. That process also doesn't take terribly long, but so you add all these things together, and we're not talking about instant change, anytime in the immediate future.
Okay. Well, you've spoken of other areas that might be interested in becoming this.
I was just going to ask you, go ahead and ask your questions because we just got this at 2:44. So this is the first time I've seen your questions.
Oh, okay.
So go ahead. I don't think these guys have even seen
I
questions.
understand that there are others that may be interested in being historic districts. I was wondering if you could share with us what areas we're talking about and how many individuals have approached you.
So there was a group that approached the mayor a while back. I believe it was Hunt Club Road. So I don't know the folks. I've never met them. I had no idea this was all per the mayor and the administration. Just the mayor, actually. So that's the only other one that I've heard about, but I have no clue the background of it.
I'm not familiar with every home we're building a structure, obviously, Hunt Club Road, they look nice.
Yeah.
But it also strikes me that the homes and other things out there may not be historic, at least to the same extent as the village.
Correct.
And so I'm wondering, the statute seems to speak to historic preservation. Can you tell me or inform me as to how it would apply to Hunt Club Road?
Well, let's be clear. So the village is not a recognized historic district in the National Register of Historic Places, which is sort of the federal designation that can apply to an area. It's certainly a collection of historic properties and would likely qualify to be designated if that's something that they decide they want to pursue. Hunt Club Road is designated by the federal government as a National Register Historic District as part of the whole Traders Point Rural Historic District. It came over 865. It includes everything up and down Hunt Club Road. So it has been certified as historic. So if the federal government has recognized that area as historic, I suppose it's well, no, I just mean, I think then it's up to the local community to decide if they, concur and want to, through the town council, want to designate that area. And I'm sure, again, that is going to be part of many conversations that would occur with the property owners between now and then. So.
Okay.
something Mark said too when we were preparing is it could be a district of one too. So I mean, we could have one or two historic houses in the town that could apply for a designation like this.
Now, I understand the commission will consist of 5 people, 5 voting members, and perhaps 1 other non-voting. You've talked about Hunt Club Road and perhaps single site districts. I'm obviously most interested in the village.
Yep.
And I suspect the village would probably constitute the greatest number of structures.
Correct. That's my guess too. Yeah.
How would you divide up membership on that commission?
You know, it's
How can
been,
we be assured that we're not going to have 1 member and 4 people who are not villagers, essentially affecting our future?
correct. So couple things on that. The state statute says the mayor has to appoint those folks. Our goal, I can't even say that because it's not my goal, it'd be her. From what I understand in the meetings we've sat in, they would want a disbursement of folks throughout the community. So I would hope that, and remember, whoever is proposed, it still has to be approved by town council. So at the end of the day, I'm going to be very involved in how this gets selected, hopefully to help, you know, get a good amount. And we don't have all builders on there, right? You know, you want architects, you want builders, you want historians, you want, you know, there's I don't remember if it says it in here specifically, but you want a well-rounded group that should include people from each area of Zionsville, because this commission's for all of Zionsville, not just one specific district.
Yeah, because just to follow up on that, John, I think somebody could ask, like, you could be a resident in the Hunt Club Road district and say, well, why would I ever want my neighborhood designated when they put 4 people from the village on that 5-member board? Do they really care about my neighborhood? I mean,
I agree.
you know, you could live in Indianapolis where they have a historic preservation commission that has 17 historic districts, but a commission of only 9 members in a city of, you know, 800,000 people. So who's representing who, you know, exactly, and whose best interests? I think we all have to trust that the people that the mayor and the town council approved to sit on here are people that have an interest, that are, we have some areas of sort of skill sets that are included in the ordinance that Joe was just referencing, like architecture, architectural history, real estate, whatever these various areas are that relate to what it is that the purpose of the ordinance
Historic
sets out to
preservation.
do.
Yeah, it says that specifically in here, where you have planners, architectural history folks, and then, you know, I like that the best way to is folks that are related to historic preservation.
I think I know the answer, but I think this will still be a question you're going to end up answering, so I'll ask it now. Exterior paint colors, it's mentioned throughout the ordinance, but the statute also provides that the commission can decline to regulate paint or color. Do you have any thoughts on that, or do you? I guess my personal feeling is that's not something that we'll want to see regulated.
So my best answer to that is that when a specific district ordinance is proposed, that's when it would be decided, not
Okay,
with
so that'll be
this.
decided by the commission.
No, so that's a great way to put this. You gotta remember, this is just for the commission to have a guideline. I know I'm gonna keep on saying that. This is for them to use as the things that are the statute can require or can have in it. So for instance, if you look back at the ordinance, which you've seen many times of the original recommended from the village district, it was not as strict as this one, right? Because this is basically just giving us the platform and guidelines to what it could be. As far as specific areas in paint, that'll have to be decided by whatever district proposes a ordinance in that commission. Then, and also I gotta make sure everybody understands is then the commission will approve or not approve paint color. And then it would go to the town council. So town council still would be the final vote on the ordinance.
Okay.
And more specifically, that, remember I mentioned earlier, a preservation plan would be crafted for each designated property or district. So the owners that are within that district, the property owners, will be assembled, can participate in the crafting of what that preservation plan looks like. And if they don't want paint colors included, they say that, you know, at that point when it's being developed, and then paint colors are not included. So then the commission knows when they're reviewing an application for a COA that they would not review paint colors in that district.
Section 2 definitions F restricts historic districts to single residential occupied structures. That raised a question in my mind. What about doubles? For instance, one of the oldest residential structures at Zionsville is a double at 242nd Street. It's featured on page 7 of the 2021 survey. I would suggest maybe that language should be explored so we can include doubles.
Yeah, that was a common question from other folks. I didn't know the answer to that.
Where is that, John, in the model
Section
ordinance?
2 definitions F. Talked about historic districts being single residentially occupied structures.
Do you remember why the word single had to be in there? Wayne?
I know the effort was to isolate this project or this effort to residential. Certainly there are quads, there are 18 unit, there are single family, there's doubles, there's a mix, and certainly
But if it just said a residentially occupied building, would that still be applicable to what you all are looking for? Or
I don't remember that question really even coming up in the past. I see what you're saying.
because then it could cover what John is raising
I don't
too.
think you necessarily want to include the apartments that are located here, but I think double family is something that is reasonable.
right, and certainly in the village, in the downtown, there are apartments above commercial. There are single family dwellings within a commercially utilized building. So definitely further clarification on this is warranted.
Okay. Thanks for calling that out.
Yeah, that was good.
Yeah, there's a generic question. I don't think I'll finish up because the other questions, to some degree, I think I already know the answers now. The ordinance speaks in terms of an accessory building. And I can understand a garage. Would tool shed or something like that be considered an accessory structure? Would be?
I think yes. So I read through the ordinance as well, and it does specifically reference viewable from the public way.
Mhm.
So I would interpret that to mean that if you did have a shed and say you purchased your shed at Lowe's or Menards, because you can buy prefab sheds, right? I think if you place that structure, and if it were permitted under the zoning regulations, if you were permitted to have that structure, if it were placed outside of the view shed, it would not be subject to the review of the historic ordinance.
Mhm.
However, if it were, it would be. I mean, that's my read on what it means.
In other communities, I'm curious as far as significantly viewable. I don't know if that's a term to choose, but it's pretty hard to entirely hide everything. And you can see things from various angles. I would assume there's some discretion on that as far as something that you would have to look real hard for. That's not really a question.
Yeah.
Well, but certainly as staff, we would encourage the lack of discretion and make it as clear as possible, such as an in-ground pool. That might not be visible because it's at grade. The Board of Zoning Appeals has heard and approved at least 2 pools in the last 60, 90 days in the village area. So this is a land use, an accessory use that might be a structure by definition, but is not visible when it's at grade and not in use.
Well, so essentially what you're doing tonight is you're talking about the commission, which will decide many of these questions.
Yes.
Right.
That's the best way to put
To
it.
explore, it's going to make a recommendation to the town council.
Yes.
I assume that would also be as to what historic districts, if there's more than one, would be included and how that would be divided up.
Yeah. Yeah. Absolutely.
Okay. All right. Thank you.
Thank you, John.
Hello, Eric Lamb, 335 West Ash Street in the Village. I don't have any real issue. I mean, we're talking tonight about a framework that if neighborhoods would want to be subjected to these rules, then they can, I guess, go through that process. I mean, I don't think nothing inherently wrong with that. What I'm really concerned with is that the way that this ordinance is drafted, it's very one-sided against the homeowner. And so what I'd like to see happen would be to make it more to make it less one-sided, make things reciprocal where they're currently in favor of one side or the other. So let me just go through a few examples I noted. And I mean, I guess the other issue too I had is I read this and tell me if I'm wrong, but the commission can essentially decide we want to make Royal Run or Stonegate or whatever a historic district. It goes to the council votes. There's no voting of homeowners themselves. Like where if I'm in a neighborhood now, there's no homeowners association. In order to put one in place, there would have to be a majority vote of the homeowners. And this is could potentially have much more restrictive rules than a homeowners association. Whereas here, not a single homeowner in theory could be in favor, but if the commission wants it and the council wants it, it's a done deal. So I'd like to see some voting of the neighborhood that's at play. I mean, having that in the ordinance, not just, well, I mean, I know you guys will do that, but what if you guys, all retire, go to Hawaii, the next regime, or maybe they have a different approach. It needs to be in the ordinance. There needs to be a vote of the homeowners. It's not in there right now. So that's one concern I have. Is my understanding correct that the commission and the council are the only votes that were required in order to have a historic district designated?
Correct. I will say though, that's why you have a council person in your district. And that's also can be put in any language when you come to a specific district. But I don't know, Mr. DeLucy, if you could answer that. Is there any kind of historical preservation, conservation, or historical that requires a vote by the people in the district?
There are. First of all, just explain the state enabling legislation upon which we model local ordinances does not require that action. So any municipality in the state of Indiana, there are about 55 that have, ordinances of this kind already. I would say probably the majority of them do not require that kind of stuff because they based it on that state enabling legislation. There are some that include that kind of vote. I know Indianapolis does. They are, I think, something like 65% support within an area for the ordinance to move forward to council. They have, I think, done an excellent job, though, and it's all in the process. It's the education, the support you build. Somebody, I'm sorry, but if there's somebody who's opposed to the idea of what this is here to do, they're going to be opposed till the day they die. I don't think they're going to necessarily ever be swung over. But if there are people who truly come into this, kind of questioning, well, what is this? And how does this affect me? And might I see the positive benefits of what this is? And they can be informed and then come along with it. Like in the Irvington neighborhood, if you know where that is in Indianapolis, they had 70% support in a neighborhood of over 1,500 property owners. That's a pretty significant effort to make and to succeed at. So even in places that have the threshold, if you will, of votes within an area, they can still be quite successful at achieving the goal. So, but that's really what you're asking for. That's really a decision here in this community, what you want to do. I am sort of the opinion that I think your town council is going to look out for you as property owners, and they're not going to be putting things into place that the members of the public don't want to see. But, again, I don't live here, you live here. And so you have to talk to your council members about what you want to see in place in an ordinance.
And I think that's great what you explained. I mean, that to me makes perfect sense because, we're ultimately talking, and like I live in the village, right? It's a hotly debated topic. I talk to my neighbors, I don't know what the numbers are, maybe half are for, half are against, half don't know, I don't know, but it's not a clear cut issue. And when we're sort of entrusting this distant board or maybe one designated council person to sort of take their, see what the weather is, I think this is what people want. We're ultimately talking about potentially taking away property rights. You buy a home with certain expectations, and if 65% of my neighbors want it, that's awesome. Let's do it. But unless we have a vote, some way of knowing, right now for the village project, there's been this, there's an organization who, they clearly have an agenda and they put out a survey. It was, you can get a survey to say whatever you want. The questions were clearly looking for a certain answer. And I don't want the town council to say, well, gosh, there's great results in this survey. It wasn't an independent survey. Let's do a true vote. And if the neighbors want it, then I'm right there with them. That's great. But let's make it a legitimate vote. Let's not just do the, fingers in the air test on that.
I guess my pushback on that a little bit would be that in 2.5 years, we've done surveys, we've done town halls, we've done over communicated, I've done videos, we've done all these things, and 16,000 people got this notification for tonight's meeting. There's what, 40 people here, 50?
Well, but this is for the ordinance. It isn't for the village. So, we can't have it both ways.
I have a comment that is related, but it's not specific to voting. And it was something I thought about when I was reading the regulations, but it's the section that relates to the removal of the district.
Mhm.
And it was my read that the district could be removed
Absolutely.
if 60% of the homeowners file a petition, which is kind of similar to a vote, right? So it's if we,
But
what I'm
you're
thinking,
taking before, you need the vote to get it in place. It's not, you don't put it in place and then make people come back and beg for that.
No, but you could come up
That's
with that 60% before it goes to a vote, is what he's saying. You
You're
could do
saying
it either
60%
way.
would have to approve before you're saying that if it's approved, it takes 60% to have it removed is what you're saying.
Yeah,
it's a related
that's the
comment,
opposite.
but it's different. I acknowledge it's not the same as a vote.
Right. It takes a super majority to remove something. It should take a super majority to have it implemented where those restrictions aren't currently there.
I disagree with that, but we can agree to disagree.
Sure. Okay. Well, let me move on to some of the one-sided things I was mentioning. So let's say it's implemented. Let's say my neighborhood is subjected to some rules, whatever they might be. And we talked a little bit at the last meeting on this, but the people who have standing to sue me for a violation include the mayor, the council, the planning commission, any neighbor in my neighborhood, a neighborhood association, whether incorporated or unincorporated, the Historic Landmarks Foundation of Indiana, the state historic preservation officer, whoever those folks are. So anybody can sue me if I paint my fence the wrong color. This is in the statute or the ordinance rather. That party doesn't have to have alleged any sort of harm. So if they don't like me, we got into an argument over something else, they can sue me over my fence color. And if they're wrong, that's no problem. They can't be found to be, have damaged me. There's no financial damages there. But if they're right, I have to pay their attorney fees. If I'm right, they don't pay my attorney fees. That's by definition a very one-sided portion of the statute. In most cases of law, attorney fees aren't provided. They're very unusual. Debt collection cases where you have a little guy who's getting bullied by a debt collector. If they win, they can get their attorney fees, but they're not paying the attorney fees to the debt collection company. It's meant to protect the little guy, not the big guy. Here, we know the town likes to, hire lawyers. And so, if the council sees me, the mayor sees me and hires these big name law firms, I'm on the hook for those fees if I lose that case. If I hire my lawyer and win that case, I walk away with a big attorney fee of my own. I don't pay your fees. It should be reciprocal. If anything, I would argue there should be no attorney fees provision whatsoever. But I think this really speaks to how this thing is drafted. It's every single example here, it goes against the homeowner. There's a provision on changing of venue. So if I'm getting sued by my next door neighbor who's the court clerk, I can't request a change of venue outside of this county, which in any other case you can. If you're not entitled to a fair trial, you move the case. The judge can say no, but I can't even ask for that here. Why are these really egregious or draconian limitations put into this ordinance? It's criminalizing the homeowner. Make it a neutral thing and it's fine, but we don't need these extreme.
So remember what we talked about earlier? This is just the guidelines.
It's the final draft of the ordinance that controls the rules.
No, it doesn't. I can't sue anybody with this ordinance. Nobody can sue anybody with this
Well,
ordinance.
no, so we would put into place the rules for my neighborhood. And if my neighborhood's rules, if they say I can't paint my fence green, and I do that not knowingly or whatever else, then this is where this comes in. And you could sue me and I would pay your attorney fees and all that.
I guess I hear what you say, and I'm not arguing with your concern of process. You know,
Mhm.
I understand the point that you're trying to make. I guess I'm just wondering what the question is. I mean, I'm here to answer people's questions, and I understand maybe you're making a comment about
Well,
the
the
content
question
of the
is-
ordinance, but what's the question?
Well, why are attorney fees only owed to the prevailing party if it's the plaintiff, but not the homeowner who's the little guy? I mean, it's a very one-sided way of drafting that portion of the provision. What was the thought process there?
I think we're following the state law here as to how state law is written.
Can that be changed so that it's neutral, or I mean, it's the prevailing party regardless of which side it
Well,
is?
again, the state law applies to many other communities in the state of Indiana.
We're talking about
written
Zionsville. We're not talking
such.
about what the state does. I mean, this is a Zionsville ordinance.
Well, no, you said, can we change? I thought you
No,
meant the
change the
state
draft.
law.
No,
I'm
change
not
the
gonna-
draft. Change the draft ordinance so that either there's no provision of attorney fees or it goes to the prevailing party regardless of which side it is.
But if a judge finds in favor of one party and that party is now able to collect attorney's fees from the violating party, why is that wrong?
Well, the way it's written right now, if someone sues me for doing something wrong and that person wins, I would have to pay their attorney fees. Okay.
I'm
that's not-
saying if
that's
a
not-
judge has found you in the wrong, I don't understand.
Well, that's
why
not normal I mean, under US law, it's very rare that attorney fees, like if I punch you in the face and you sue me and you win, I don't pay your attorney fees. I pay you for your medical bills or whatever else. But if I paint my fence screen and you sue me, I pay your attorney fees. Attorney fees are only available in the US if it's provided by statute, which this here does. On the flip side, if you sue me and I win, you don't pay my attorney fees. So my issue is why doesn't it go both ways? Why does, so if you sue me, I'm done. I'm not gonna fight you because if I lose, I pay your attorney fees, but you don't pay mine if I win. It should go both ways or nobody should get their attorney fees is my point.
The first thing you'd have to do is violate the ordinance. right?
Allegedly, I mean, this is all,
Well-
just because you get sued doesn't mean there's never a presumption of wrongdoing.
But the ordinance is designed to protect structures from being demolished, right? So,
Changing any physical changes whatsoever, including destruction, that's one of them.
well, so number one, I'm not an attorney. Are you an attorney?
Yeah.
So this might be a conversation that's better had with another attorney, but I'm here to talk about the design, right? So I can tell you as somebody who's seen structures demolished and altered, that you can pretty much see it, right? So this ordinance is designed to protect existing structures. And if the intent is to protect those structures and that district's put in place, that's what the ordinance is designed. So it's not really, I think you're taking it to mean it's not protecting the homeowners, but what it is it's not protecting the person who demolishes a historic structure. And I agree with your statement, it's true, but the purpose of this ordinance is to protect the structures. So that's why the enforcement penalties are written in this way, because it's designed to actually fundamentally deter people from destroying historic structures. And this is a financial penalty for doing so. So that's why it's written that way. And as Mark said, it's based on the State Enabling Act. So it could be changed. I think that this question is really a question for the town's attorney, though. No, I don't think anyone on the panel tonight's an attorney. So I don't want to respond about the legal ramifications about enforcement. Does that make sense?
No, it makes sense. I mean, my only point is that in 99% of the law, attorney fees are not provided to the prevailing party. And if they are, they're provided to the little guy if they win, not the big guy. And so I'm only asking that this be consistent with that. I'm not against a framework that allows for historic ordinances to be put, or districts to be put into place. That's fine. I'm just saying, let's make it a level playing ground. Let's make it so the homeowner isn't going to be up against attorney fees if they lose, but they don't get their attorney fees if they win.
I think it's a
Can
good
you
point.
tell me exact, can you point out, or do you have that in front of you, what section? and
He's
what-
in
Section
section 14.
Okay,
Right, yeah.
It is in there exactly as.
Yeah, I
as
mean,
you
to your
out.
point, I mean, I totally, yeah, if I go knock down my house and it's a whole beautiful home, I get that. I mean, if I'm a horrible actor, there should be accountability, but the way that this is drafted, any violation of these historic district rules, if it's violated, could trigger these provisions. And we're all reasonable people, we would never do that, but it also allows my next door neighbor to sue me. And we don't know if he or she's right there, she's not a reasonable person. I can tell you.
but that's the thing, drawing that line between who is horrible and who isn't.
But I mean, the
it's
point is, if it's
that's
an
a
old-
court's decision. The way
No,
this
it's
is
not.
written,
It's allowed to, it's to be given to the prevailing party. It's not at the court's discretion. And so, I mean, just to give a very quick illustration, I paint my fence green, my neighbor doesn't like it. And she sues me, and maybe I thought I could do it. Who knows what my justification was, but she sues me. And if she wins, the court has to award her attorney fees. And, that's a bad day for me. If I win, we all walk away, no big deal. But, I was put through this machine that I know, maybe I was blatantly right, but she thought she was in the right. There's no recourse for me. I'm just saying, let's make it equal to both sides. The homeowner isn't necessarily tearing down houses. The homeowner could just be some guy that painted his house green by accident. So the penalty needs to fit the crime.
I think I'll just tell you in terms of like zoning cases and things like that. It's very uncommon for something like painting a fence to ever have the type of penalty that.
Well, understood.
you're
It's a
talking
silly example, but
Yeah.
I mean, when you're enabling any neighbor to sue somebody for any violation, you're creating an ability for them to get their fees. It's not discretionary. It's required under the statute. So I'm just saying, let's clean it up, tighten it up, and make it work in a way that
Can you state that what you just said again? It is required under the statute. This says may recover. It doesn't say shall, and shall is the requirement.
section, where is it? Section
14E. An interested party who you're suggesting would be a neighbor who obtains a favorable judgment in an action under this section may recover reasonable attorney's fees.
You're right. You're right. I misspoke.
So a
It's-
judge doesn't necessarily,
have
isn't
to, but
required to
I
give
mean,
attorney's fees.
Sure, but to my point, it should be reciprocal. If I win, I may be entitled to my fees. If you win, you maybe should be entitled to yours, but it shouldn't just go.
Well, I'm just pointing out, we
I
need
know, I
to make
appreciate
sure
that.
language is correct here, because I don't want 50 other people to think
Thank you.
that
No,
the
you're right.
information you provided is accurate.
No, I appreciate that. But either way, it should be reciprocal. It should go to the prevailing party, not
Point
only
taken.
to the plaintiff.
We'll take a look at it.
Okay, sure. And I think it's the last thing I want to just mention briefly. The ordinance allows the town to issue fees that would be pursuant to a later to be determined fee schedule.
Yep. Well, actually, I think, does it say what the current fee is? Is that?
Oh, no, I'm sorry. I'm talking about fines. I misspoke.
Okay,
Fines.
okay.
Yeah, so, and this is not part of that suing process. This is section 15. It talks about the
Yep.
town can issue fines. It doesn't say what that process is. Who determines whether a fine's appropriate, so can you speak to that?
I'll
These
leave
are
that up to Wayne on that answer to that question.
Section 15.
Right, so those numbers would be appearing in a future fee schedule.
Well,
That will be
understanding, but
identified.
who decides?
Town
whether I have to
council.
pay? Who decides if I have to pay a fine?
Well, that information would be contained in the future documents, but as these are a town ordinance, it would be the town council that would enforce the
I
ordinance.
think what he's asking is like, say he went out, I'm sorry to use you as the example, but say you went out and started to put up an addition on your house without having gotten an approval from the commission. Who in city government is it the building commissioner do you have enforcement officers within your department that would do a stop work order, or would go out and issue a fine, or how does that work?
We do have all of that structure as identified in the building code, identified in the zoning ordinance. That particular structure has not been identified yet. It appears based upon section 4 that most likely that responsibility would squarely fall within our department, and the same individuals within the community and economic development department would do that same, those services. I don't want to speak out of turn if there might be a change or something like that, but that seems the way this is currently put together.
Okay, well, I appreciate the time. Just to summarize quickly, I mean, I'm not against the ordinance in general. I think it's fine to have a mechanism for this. I just like to see, I'd love for there to be a vote in the neighborhood. I think that would be awesome. And then number 2, I think we need to make the attorney's fee provision reciprocal. So the prevailing, or take it out altogether. It's not normal. We don't need it. But if you're going to have it, make it reciprocal.
Okay, that's fair.
Thank you.
Thank you for your time.
Thank you.
Can you state your name and address, sir?
Sure. Ralph Stacy, 60 South 2nd Street. I really wanted to start by saying this month will be my anniversary that my parents brought me here 76 years ago to 60 South 2nd Street. But I just wanted to, Joe, I enjoyed the video that you and Amanda Avila did. And one of the comments you mentioned was the outlying areas had some interest, and you kind of explained that tonight. I was just reminiscing when I heard that, because I can remember over 20 years ago when Mrs. Sutphin and Mrs. Fortune also attended the National Preservation Conference down in Cincinnati. And I can remember stopping in the hallway, and they kind of told Jan and I, my wife and I, about what they were up to and what they've accomplished is something to be proud of. And I just wanted to tell you that I want to thank you for following through on this, and I hope it does come about. But in your conversation with Amanda and yourself, and mentioning these sites outside, let's say the village, it came to me that, the Boone County interim report was, I think, done in 82 or 83. And then there was the Zionsville interim report. But since then, we've actually done away with township government, and we did away with Eagle Township and Union Township, which also have some historical structures, also some architectural jewels. And we don't want to forget those. I just wanted to, but when I listened to you and you mentioned that, I thought, those reports were done in 83. The reorganization was done many decades later. So we don't want to forget them. But thank you for what you're doing. I appreciate it.
Thank you.
My name is Barbara Valonis, and I live in Royal Run, which is probably not going to be one of the districts, but I am wondering about farmhouses and what is going to constitute, will the commission decide, a historically significant property. So if a district is made of mostly farm property, and there are a few left in the Zionsville city, would one or two structures be better served by registering that property only rather than trying to register the whole district?
Yeah, so just to point out again, I think we sort of said this, touched on this earlier, but a district as defined can constitute more, and most normally, a number of buildings, 50, 100, whatever. But by this statute, it can also mean one building. So it's called a single site historic district. So if a property owner or owners of one or two buildings, whatever, want to go in and just do a designation on a single property, a farmhouse, for example, or a farmhouse with a barn, then they can do that. They approach the commission, they'll craft the preservation plan, and ultimately the ordinance that goes forward to the town council. So,
I lived on Meridian Street in the historic district for 38 years. And I was there the first night when Reed Williamson came and approached us about the whole procedure. So I've been through the whole thing. I know intimately what it is and how one lives under it, what it involves, at least ours, on what can be seen on the structure and what can't, the facade. One of the big ones that nobody mentioned when talking about sheds is chimneys. Chimneys became a big deal. If somebody wants to take down a chimney, remove their fireplace, and was that visible from the street or not? And then we had another big issue with a house that applied, a more recent house. I think the house was built in maybe 68, which didn't make it historically significant necessarily, but they were in our district. So my question is, how tightly do you think the commission will follow, whether it's historically significant or whether it's just part of the district that got registered? Do you think that that would maybe come before the commission in what you're drafting for a commission? Do you think that the commission might put historically significant? Because we keep talking about historic. Do you think that would be strictly, how do I want to say it, followed, or some leeway? Did I ask that correctly? Did I make myself clear?
I'm wondering if we could talk about how non-contributing structures might be treated.
Yeah.
Is that what you're referring to?
I think
Like
so.
Meridian Street is mostly 1920s and 30s mansions, but then there might be a 1968
There were a
ranch that
few,
got built.
yes.
And so the 20s and 30s mansions are going to be what are referred to as contributing structures to a district. The later homes were considered non-contributing
Right.
to the district. And that would mean that the commission doesn't regulate necessarily all changes to the non-contributing properties in the same way that they would to a contributing property. So like if you're referring to, say, a subdivision of 1980s houses
Right.
that has a 1880 farmhouse sitting in the middle of it because
Right,
it was
exactly.
a clubhouse or
Exactly.
changed into that when the subdivision was built. I would say in an instance like that, you're going to do a single site designation
Yeah, I would think.
of the farmhouse, and all the other properties are going to be left untouched. They're not even going to be designated into any kind of district. So
Do you think there would be a probable clause, I don't know what to call it, put on that single farmhouse, for instance, that would extend out 500 feet in either direction?
I guess it could. It just depends on the amount of available property that goes with it. So if it has
It
that
would
kind of,
be probably restricted to that property. So if the barn sat further out, it could, could include that barn probably,
yes,
but maybe not a neighboring property that might
No.
be closer.
no, not if it's a non-contributing. I don't see the reason why the council would want to protect something that's really out of step with the primary historic building that you're trying to protect.
But we are talking about historic buildings primarily.
Right. Yeah, I mean, I do want to point out, it's going back to your Meridian Street example.
Right.
Today, they view those ranches as historic now.
Well, that's right.
In 1974, when
That's right.
Reed worked with you on the designation
Right,
of the
right.
Meridian Street District by the state of Indiana, not
Well,
a
we had
local.
two laws. We
Yeah.
had-
But that means that, that's the evolution of time, right?
Right,
So
right.
back then, they were like 10 or 15 years old,
Right.
not even that, when those houses were being built. So now they're 40, 50 years and they're viewed as historic in and of themselves. They're just different than the predominant
Right.
building type in that area of Meridian Street.
Does one change the listing then to include those or change
Yes, ma'am.
so my book is out of date?
I think it is. Yeah.
I can still sell it for a lot.
Thank you.
Thank you.
JD Hall, 150 North Main. Thank you guys for your help and all your work. Got probably 3 or 4 things here, so I'll try to keep it in question form. So I know you talked about this is a guideline. So my question is, because this is a guideline, will you put a box in here or a paragraph in here saying nothing in this document is construed as mandatory within each commission? So the Hunt Club Commission don't have to use all of this. They can pick pieces and parts out that they want. Because if that's not possible, I don't support any of it, just for the simple fact of sections 14 and 15. All of this litigation talk is to me ridiculous. And so these commissions need to be able to use an a la carte approach and pick out of here what they want. I understand some people may want it, some people may not. So my question is, will you put in a section here that exclude or makes it possible for these commissions not to use sections 14 and 15 or any other section?
I can't do that on 14, 15. I don't want to speak for Mr. Delosi, but I don't know how you take 14, 15, because then everybody can just do whatever the heck they want.
Okay.
Then there's no point of having an ordinance. That's my opinion. You guys tell me.
The question that I would ask, well, so I think it's implied, right? The idea that they're going to enact an ordinance for any district once the commission is formed. I think it's implied that sections of this may or may not be included, right? I mean, whether we put that in or not, it's the truth, right? All sections don't have to be included. We've heard that from everyone here. That's the next step in the process.
I would feel much more comfortable if it were in writing.
Fair enough. But the thing I was going to say on the enforcement, right, is I would ask a question is, I mean, do you want any enforcement or any penalties?
No. So I think if the town council that would decide to take me to court over something major, if I elect to change out my lights on my garage, do I think the town council would take me to court over that? No, I don't think so. Is it my advantage to keep my house, which is an older house, 1880? I want to keep it that way. And I think most people that came up in September, of course we want that approach. But when you start talking about litigation and neighbors suing, and I may have someone from Spring Knoll sue me because I removed a bush or they don't like my fence, that's ridiculous. So I think it needs to rise to a level of a town council taking me to court. But for neighbors, renters, and other owners, that's crazy talk to me. So I think it needs to be documented in here that they get to pick and choose out of here.
I just have a question for you. How would you possibly take out section 14 and 15?
I have no idea.
There's no point for an ordinance.
If somebody demolishes a historic house, for example, and there's no 14, 15, there's no ability for somebody to say, so.
Okay,
how do you penalize
let me ask
somebody
you
for
this
that?
then.
Okay.
Will you delete item, let's see, section 2, item G? Will you delete 1, 3, 4, 5, 6, and 7? Which would then say the town council can take me to court. Because I don't see the benefit of the state historic preservation officer taking me to court, the Historic Landmark Foundation taking me to court. And I don't know if everyone here realizes that's what could happen, but that's what could happen. So my request is, can you take out those?
If you're looking at me to make the decision, I am not a decision maker on the town council.
Okay, I'll look at Joe then.
Yeah, no, again, you've
It
read
needs
this.
to rise to the level of litigation, something serious. One of the other neighbors brought that up.
Yeah, well. No, I agree. I think we talked about earlier is I gotta have the lawyer look at this.
Yeah.
I mean, I'm not a lawyer.
The question is, who is defined as an interested
Right.
party and what their rights are.
Right.
I do think that's something we should refer to the town attorney.
Yeah,
And I would just say, you know, even the town zoning ordinance has penalties and
Mhm.
outside of the town zoning regulations, there are property rights issues between your neighbors. So
Mhm.
this penalty section to me is not inconsistent with the types of penalties you see in zoning ordinances. I think the question of interested
Yes.
parties and what the
Mhm.
penalties should be,
Right.
those are
Yeah.
perfectly good questions to ask and to
Agreed.
raise. So I
Yeah,
appreciate the
I
comment.
have no rights on what goes on Hunt Club Road.
so,
Conversely, they have no rights what goes on in my district either. So,
yeah, so it says an owner or occupant owning or occupying property located in that historic district established by an ordinance adopted by the town council.
mhm.
Where is Spring Knoll going to mess with someone in
Well,
that
it
district?
says that anyone in the town, somewhere back in here, it said the town, what is it? 2G4.
Yeah, it's the historic district.
That would be a neighborhood association in a historic district. So if the village had a historic district, had a.
Yeah, tell me a page. I want to look at that.
So it's page 2,
Okay.
item
G4.
G, 4 and 5. The whole section, interested parties, defines who could be considered an interested party.
Mhm.
Correct.
I think the intent is for to say of that specific historic district, which I think to make that, but
Right.
the way it's worded says any historic.
I like that. Yep.
Yeah.
I just have to, I mean, I like it. I guess get the attorney tell me, but I think it's a good point.
Mhm. So, yeah, going back to, I just want the folks in our district be able to have input what goes on in our district. I have no input into Hunt Club.
Yeah, so I think that you're bringing up very, very, very good points. Taking more stuff out of this is gonna be a lot harder for other districts. You see what I'm saying? If I
Well-
take anything out of here, then it's gonna be, that was the whole point of having this, is so that the district can have a
Yeah.
guideline to come back to.
So the CDC with coronavirus, CDC had guidelines. Everybody adopted all of the guidelines. So you can't say guidelines are à la carte, you get to pick and choose, because that's not what happens. And that's the danger with saying, well, these are just guidelines. If you put in here a box saying nothing here can be construed as, mandatory, then that will give that commission the ability to say, okay, for our commission, the only people that we want to have sue us for a violation would be the town council or the mayor or whatever. But I think when you say it's just a guideline, people will take it and lock it in as that. And that's what I'm vehemently opposed to.
So
And others
I
having
agree.
comment into our area.
I think I agree with the point you're making, and I would say just an editorial comment, right? So I think the idea is to have everything in here that any district could do, right? So by eliminating things, we might take things off the menu that we actually think are good. So I think providing
Go back to
feedback
my
on what you
original
think
point.
is good and what you don't think is good, that's valuable.
Yeah.
But I would say the goal is to actually get a model that would be utilized. We want everything
Sure.
in here to be good.
Yeah,
And so I would
that's
say
great.
in talking tonight that this is a model ordinance, it's not the ordinance that would be adopted. I think it's also a goal to say that this is the model ordinance we would provide the historic district commission to adopt, right? So I think we do want to endorse these standards is the point I'm making.
We would definitely want to endorse these because this is the state statute. What that specific district wants to do, that's up to them.
All I'm asking for is that you put it plain and simple language here so it's in writing. Because my worry is when you say this is a guideline, it gets adopted wholesale. And that's where I don't want to be. I think that's where some other folks don't want to be either.
Well, yeah, but this doesn't have any teeth on it towards anybody, this ordinance. This doesn't impact anybody from the aspect
But
of,
once you pass it and you call it a guideline, then it does.
nope, not until the district's created. Not until there's a preservation or conservation district does it impact anybody.
Okay, but once it's created, don't they then pull this out and go, this is what we're gonna do?
They can build it however they want. If you remember, the conservation district that was recommended was a lot less restrictive than this. This is just,
Right.
so you'd have to
Mhm.
take that up with whoever's in your district when they create it. There'll be town hall meetings just like this. There'll be.
So going back to my original intent here is, can you put wording in here that says that the district can pick and choose from this draft? And I like the word that you used. What did you use?
Remember, did I say menu?
Menu something, but yeah, I like the word that you use, but don't lock us into this. And then I'll be good if we don't have.
I hate to go back to you, Mark, but I mean, what?
Maybe we can look back at the video and see what everybody.
Yeah, I was thinking the same thing. Yeah.
I mean, I think I stand by the ordinance as it is. Of course, we are here today to listen to people's comments. And
Yeah.
I mean, we've already been, this gentleman back here that's in line again made a couple of points that I have in here as potential changes related to legal fees and Mr. Tousley made the comment about single residentially occupied buildings. Maybe we need to broaden that. I mean, are we going to throw out the ordinance because one person doesn't necessarily care for it? I don't think so. At least.
I'm just worried if you can have a chilling effect, because I won't change anything on my house as long as all of these people have a chance to sue me for a color of the fence. I'm not going to do anything. Why would I? It would make no sense. So I think we want to continue to improve our community, and as broad as this is in the language in 14 and 15 and giving anyone the ability to take you to court, that's a bad precedent. And all I'm asking is, will you put limiting language in here that allows those districts to pick and choose from here? I won't belabor the point anymore.
That's fine. We'll look at it.
Thank you all for your help.
I appreciate it.
I also want to say thank you for everything you guys are doing. I really appreciate it. Michael Sechrist, 300 West Oak Street. First thing I theme seems to be that we're all worried about being sued, which I find really unusual. But a couple of things I wanted to make a point about was this is just a draft, right? To see if the commission approves it.
Yep.
I think we're kind of getting buried in the minutia maybe a little bit. The other thing I wanted to make a point about was the houses that are non-contributory, if they get torn down, this historic or conservation district, it's still going to do that thing that we talked about forward, still protective in a streetscape, which I love that word, kind of situation. Are we still looking at that as part of this situation?
I think that'd be according to the ordinance that's created for that district,
You
right?
mean streetscape like?
Well, we have several
street lights
examples.
and street furniture and sidewalks and that kind of stuff, or what do you mean
I'm
streetscape?
talking about if you got a cute little bungalow house and the house beside yours is non-contributory, somebody comes in, tears it down, builds a. That's my concern is it's like, great, my house or my neighbor's house is safe, but somebody comes in and finds a house that was, that's not included. Is that something that's still going to be, looked at in these guidelines?
That'll be up to whoever creates that ordinance for that specific district. This is just to give them the opportunity to use these, this plan towards whatever, however.
I like the term framework.
Yeah, framework.
This is like a framework.
Yeah, not guideline, but framework. Yeah, I like that better. I don't know how to answer that because I don't know what the district's going to come up with.
So it'll be up for discussion and
Yeah.
there'll be things that are considered. Okay.
Yep.
And then the only last point I would make, I think you brought up was that there's 55 such historic type districts in Indianapolis.
No, there are
Or Indiana.
55
Indiana.
commissions in Indiana. There's many districts
Within
in
that.
all those cities within those 55. Yeah.
And I guess I find it odd that a lot of times people come up here and speak and they're like trying to either, not to pick on anybody in particular, but trying to get things removed from things that have been working for a long time. And obviously there's a reason, like you said, that why create anything if there's no, you got to have a little bit of a threat of a penalty, or no one's going to, adhere to what the rules are. They're just going to do what they want to do. So again, thank you.
Thank you.
Thank you.
Don't worry, I'll be short this time.
Okay.
I just wanted to make sure I understood kind of what this ordinance is relative to the rules of the historic district. So the words that kind of brought me back up were the word, I think, menu, or maybe, I think model was maybe a term. So my understanding, tell me if it's wrong, if this ordinance is passed in this form or whatever other form, it's an enabling ordinance. It allows there a commission to be formed. That commission can designate neighborhoods to be historic districts. And then rules would be established for those neighborhoods. And it may say you can't change your paint. It may say you can, but that's up to whatever's relative to that neighborhood. So those are the minutia details that I think ultimately people are going to be more concerned with. And so it's not like this is a model that could apply in piecemeal to those different neighborhoods. This full ordinance would apply to every single historic district in its entirety.
Correct.
This just dictates how those individual neighborhoods would apply their specific sub rules, right?
Absolutely.
So you
Correct.
can't strike section 14 from neighborhoods 1, 5, and 6. It applies to everybody, or it applies to nobody.
Yeah.
So these are the bigger scale. So if you violate the neighborhood rule, that's what triggers section 14 up here, potentially.
Yeah.
Okay, just wanted to make sure I understood how they interplay.
You stated it spot on.
Perfect. You're on the board next time. By the way. Yeah, you're already on the commission. You just don't know that yet.
Up here yelling at me.
He's
I don't know, I
taking
got fixed,
names.
And addresses. I know your address now too. So.
My name is Tom Monroe. We're at 445 West Walnut. We bought that home about a year ago with the intention of restoring it. We love the village. I admire a lot of what is going on here and what you're trying to do by preserving it. We want to do that with the home that we bought. And we're working with Todd Rotman right now, trying to make sure we do things that are pleasing to the neighborhood. The biggest concern that I have, and the neighbors, several of the neighbors that I've talked to, I came up because I heard somebody say just because of one person. Well, we're not just one there's more than one person that's genuinely concerned about the litigation. And we kind of put the brakes on what we're doing with 445 until we see what's happening with this. Right? Because I feel, as somebody coming in that's going to make a rather significant investment and improve the property, the genuine concern that I have is what people are capable of doing, not what your intentions are. All right. It's the way the documents are written. And I'm not going to point out just one specific clause. There's several of them. Right. And it's the amount of exposure that I would feel, as well as many others, that we would have if there's a bad actor on the other side. It does make sense to, for attorney's fees or whatever. Not that I'm worried about getting sued right now. I mean, I'd like to think I'm going to make everybody happy, but I'm not. Okay. And with as good of intentions as we have, I don't think it's possible for anybody to do that. And if we've learned anything over the last couple of years in this polarized world, we can't all get along. Right. And if you're allowing people to do things based on the content in that document, there are going to be people that will pull the trigger on that. And it's, I want to be fair too. Right. But we're all different. And an interested party not allowing their attorney's fees to go back and forth, things to seriously consider. And that's why I want the neighborhood to prosper and the people to invest in it for all the reasons that I want to do it, but I can't do it with this document, and I won't support it the way that it's written now. Thank you.
Okay.
Hey, guys.
Hello.
Michael Marlowe, 140 North 4th Street in the village. Excuse me. Lived here for 5 years, have 4 little rugrats, definitely running around and enjoying our small village environment. I guess I was always confused about this, I guess. I thought that the ordinance was actually something that we were moving forward with. And my confusion, I guess, is, I guess I'm hearing 2 different messages, because I'm hearing that it doesn't matter, and I'm hearing it does matter. And I think there's a lot of my neighbors that are confused as well about this, right? So those of us who aren't, certified attorneys and don't know all the language, some of the words in here are a little scary, and endorsing it is a little impactful, right? I mean, because you set the tone, you build the roads, you have the police, you're a government, right? So you let us go places and tell us not to go places. And so some of the things in section 14, it's like, I don't think anybody's saying eliminate the penalties. I think the concern is all of the penalties, right? And I don't know when the right time is to bring up questions. There's a lot of support in the community to protect the architectural integrity of the history of Zionsville and the history of the village. I think all the surveys and the things you've heard are around that. The support is, yeah, let's preserve the things that are great. But when you actually get into the wording, it doesn't say that to me as I'm reading it, right? Not everything. Some of it's, okay, we're protecting the integrity. There's, that's the intent. Clearly the intent, I think, is good. But I guess, so my question after that little diatribe is, when's the right time to weigh in on the specific language? Is there a vote to the language? Is it we wait till there's a historic district and then we involve ourselves? I'm just looking for guidelines from you guys as to when my opinion's gonna have an impact.
I think your opinion has an impact right now. I think there are 2 really good points tonight about the interested party. I got my notes. I think that is a very valid from Mr. Hall. I even emailed him back today. I think that's a very, 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 important thing we probably need to talk about. And I also think that the fees for litigation on both ends, that's a valid point.
Can I add one too? To that list is somebody pursuing you legally before the action occurs, which is 14D. If you read 14D, a neighbor, so there's this enablement of bad behavior, which I think is just a concern. We don't want to make it easier for people to do bad things. And the way I'm reading it, if somebody drives by my house and they see I have blue paint cans on my front porch, and they didn't see that I got my certificate of, what is the word?
Appropriate.
Thank you. Certificate of appropriateness, that I did not get that I could get pursued legally as a neighbor. That's the way I read that. And so I just, a guideline, I get the point of, we want to give a lot of leeway to the local historical preservation society, right? To do what they want. I understand. I've heard that a couple of times from you, and I understand it.
Yep.
But under what circumstance is that okay? That somebody could drive by my house and just, do that? That's how I'm reading it. So if it's not the way it's written, then that's okay.
I understand the concern. I'll make a comment. It's similar to one that I made earlier, right? And I find it to be very unlikely that you're going to get sued, or that someone would come to the town and say this person has paint cans on their porch, and that would blow up in the way that it's being talked about tonight. What this to me says is, if somebody has a bulldozer on a lot and they're about to demo a building, that we can stop them from doing that, that the town can stop them from doing that, or an interested party could observe.
And I think the interested party thing is really a big deal. So just to emphasize that, there are a couple of other people that mentioned that. I think if the interest party is you guys, is the government, sorry, I don't know which. Mr. Cup is the government, then I think that says something different than just anybody can do that. So suing people should be hard to do. It shouldn't be easy to do. I mean, it should be, that should come from, if it's a city thing, it should come from the city, I think, just that's my own 2 cents. But, I have yet to, I can't think of a reason why that's a good idea. So to make it easy for neighbors to fight each other.
Going back to the purpose of the ordinance, right? Like, if there were bulldozers about to demo a contributing structure or possibly even a significant structure. Would it, you stated that you thought that the intention of the ordinance, the purpose of the ordinance was good, and many of your neighbors, including yourself possibly, would support that. Do you want there to be recourse? Do you want there to be?
By the state, to answer you, by somebody, by a zoning commission. So we got our house approved, went through a very thorough process on it. And I don't regret going through the process that we went through. I mean, I don't think it's, I don't think it's wrong for people to ask certain questions or to make sure that the development in the area is good. I mean, so that was all fine, but I think those questions should be asked more so from, Mr. Cupp's office than a bunch of my neighbors saying you do this or else, and I understand that's not your guys' intent, but whenever we read, or whenever I'll speak about myself, whenever I read certain things and I'm looking at this, it's what we stand for in our community. And we have a great, warm community. We all care about what's going on in Zionsville, or we wouldn't be here. And you've gotten, I don't know how many thousands of emails you were stating. So, I mean, we all have an opinion. We want this place to be
five emails.
Yeah. They sent out 16,000.
No, not this one. I just meant along the way. I mean, the survey had a lot of results and all that. I just meant energy around.
Oh, okay.
There's a lot of people that, right, they care about protecting our, that's what I mean.
Yeah.
Yeah.
He mentioned the ZVRA, is that right?
Yeah.
That worked on this.
Yep.
Yeah. Anyways, the point is, I'm not sure when the right time is to make the biggest impact, just to make sure the language is representative of what you guys are intending to accomplish. I think what our neighbors really want to accomplish too.
Yeah, I think definitely the attorney fees, interested parties. I mean, that's something I'm going to look at. I think that'll resolve some of that. I thought those were good points.
And just to follow up, I mean, because you were asking about key times. I mean, as Joe said, this ordinance will put the framework into place. There will be another ordinance that will come along next that if, say, it's going to designate the village as a locally protected district or conservation district, you said you were a resident of the village, is that right?
Yep.
That would be a really good time for you to have input into that process, both from an ordinance standpoint as well as the development of the preservation plan. So what is this going to look like, this guiding document for that will be applied to this district? So making sure you're engaged in that process would be a good time too.
Okay. Maybe you can help me with understanding when to, I don't know if there's a calendar or something to.
Well, we haven't passed this one yet.
Well, just to make it part of the guidelines. No,
we
were talking about guidelines and structure and all those kind of things. I just think making people aware of the right, times to weigh in on on specific language items would be nice to.
This is it right here.
Okay.
That's why we're here.
Yeah, no, I just get, that's what it matters or doesn't matter. So at what point does it matter? Hey guys, it's just the final draft and it's up to the local areas to do that. So I hear that. And then I also hear, this is the right time to tell us what you want in there. So I'm not sure how to answer you when I hear both.
Well, I think this is the right time to ask any question.
It's both. I mean, now is the time.
And then if you don't like what was changed, well, you can come to the first reading, the second reading to the council, whatever. I mean, Wayne and I are going to go back with all these questions and answers, and we're going to go back to our group and we're going to rewrite it for, based on what the state statute allows us and what some of the interested folks here bring up their, 2 cents. And then you can come and speak at the first reading, the second reading,
Okay, well, just to make my opinion super clear, I just think we should rein in 14. You don't have to eliminate it, but I think if you rein it in, that'll have a positive impact. And by rein it in, I mean.
Reining it in or changing the interested parties?
Interested parties is a big part of it, I think. I think if you're limiting who has the power to be litigious, I think is pretty important. So, that would be the biggest one.
Okay.
Thanks.
Thank you.
Just one quick point. I think sometimes we're always looking for the government to, back to the Sioux word, and do those things. But if something happens to the property next door to me and my house value goes down, or it can't sell because of the, whatever gets built next to me, then I am harmed personally. So I do have some in the game, you know? So I just want to make sure that when we're trying to rein everything in, and again, I think if Indiana has these, there's a reason why they're so successful.
Thank you, everyone, for your time. Dave Dam, 155 North Main Street. A couple of things, so I'll be real brief because I feel like I'm beating a dead horse, but the interested parties making me very nervous, and I feel exposed on that. Not that attorneys are bad, but what would stop an attorney from being very entrepreneurial and hiring a couple of interns to go out and find out what the ordinance are in this town and start bringing up whatever cases you can, and we'll get billable hours. I think we're exposed on that. And then down into the minutia side, I'm a little concerned. We talked about the historical ordinances would typically raise the property values. I'm looking at the certificate of authenticity process. I think the last meeting you were estimating about $800 to file that claim and get that through. So as a homeowner that is going to buy a lot and redo the house all at one shot, $800 is not that significant to the total project. But if I'm doing my house colors today, my siding to next year, or my windows the year after that, all of a sudden I've got $5,000-6,000 in fees just to get that approval and do a yearly project. And so I'm concerned that that's going to slow down the maintenance and upkeep of the village for the people that are not coming in trying to do a one and done, but just trying to keep the authenticity of their properties up and doing a yearly maintenance on that. I don't know if you've got any data to support whether that occurs or not, but definitely I think a point that we need to take into consideration.
I think that's actually a very good point, but that's a Wayne. I was gonna say the same thing. That's a Wayne answer.
Well, and that previous answer was generated when this effort was squarely focused on the 580 some odd homes that were comprised of the 2021 survey that appears on the town's website that was paid for by a couple different parties and completed by Sullivan Munts. And so what we did to calculate that $800 fee, again, just an estimate, and that is also on the assumption that the town council's strategy to fund this project, this ordinance, this program is to have it fee neutral. So we took the activity over a 24 month period, looked at that area, compared it against the addresses, indicating it was like maybe 24 permits that the town issued in that 24-month period that would have resulted in a certificate of appropriateness being issued. Looked at that, times up by the staff hours that would go into that, and looked at the costs of hiring the attorney to staff the board, having the benefit of the Indiana Landworks folks helping us out as well, and other soft costs, if you will, as plus some training, and dividing that out, came up with the $800 fee. So that's a pretty long way of describing our previous effort, but how that works today with what districts are to be created, if any, that I think that calculation is going to be different, and then certainly would ultimately be decided again to what strategy the town council wishes to seek, either fee neutral, have some of the costs burdened by the town, carried by the town, or something different.
Yeah, I just don't want to lose sight. We're talking about a tool that, to your point, we don't want to bulldozing down a house. And those are pretty dramatic and fear-intensive projects, but we also don't want to rotate that pendulum and prohibit the day-to-day maintenance and upkeep of the.
And I think you make an excellent point. Most people don't, or maybe can't afford to make those huge renovation projects all at once necessarily. And so one year they might take on repairing siding or tuck pointing masonry. The next year they might do painting. The next year they might put a new roof on. And so it's a ongoing maintenance thing, not just a huge renovation investment in their property. So I think it's a good question. That's not, I think, on the ordinance side. I think it's more kind of on the process side of the city as they look at this. So
thanks again for your time.
Thank you. Great question.
Sally Zalonis, 40 South 3rd Street in the village. I thank you for your work. And one thing that I want to point out is that This is the town hall meeting. And so the process going forward, as I understand it, is that there'd be a first reading for the town council meeting, second reading for the town council meeting, at which point you would vote on the ordinance whenever it's redrafted or whatever. And for those people in the audience who don't know, the town council meetings are the first Monday night of the month and the third Monday morning of the month. That being said, I'm understanding that anyone can request a permission to speak at the town council meetings, if you don't know that. And any concerns that haven't been addressed by the redrafting would be heard by the town council at those meetings. I just want to point this out to people in the audience so they understand that there is a process by which you operate, and I appreciate it. One of the things I would ask is when it's redrafted, how will that be made public?
Good question.
Well, you have the current
Yeah,
draft on your website.
yeah, I could just leave it in the same spot.
Right. So I would say like draft number 2
We'll
or
call
something
it
like
the
that.
new draft.
Yeah.
Right. I know, Joe, that at the Monday night meeting, it was Monday night, wasn't it?
Yeah.
You suggested that you'd like to have the first reading at the next meeting,
Yeah, March 21st.
March 21st. I'm not sure.
Unless
if-
something catastrophic was asked tonight that I would take us a while to research.
Right.
But so far the questions are reasonable and I think
Right.
it's something we can go back.
So
and-
people may know to be on the lookout for the 7:30 a.m. meeting on March 21st.
Yes.
And that would be the first reading. So if you wanted to be public with your comments, you'd have to request to speak 3 days ahead of time. And there is a procedure to do that through the town clerk's office. I just want people to be aware of the opportunities that they have.
Yeah.
One thing that I just don't hear that everyone is understanding that the ordinance that you have is a draft. And yes, you'll put forward for the final reading, but it's a draft to establish this commission, and that anything that's going to go forward for the village in particular, there'll be another procedure for that. There'll hopefully be a group of very concerned village residents who have shown their support through surveys and committee work that's been done over the past many years. And so if you do live in the village, concerns, that will be a time to raise it with that committee that will draft the guidelines for the village, not for Ford Road, not for a single district or a single site. So I just want to point those things out. I've been very actively involved in attending meetings, and I'm not sure that other people are aware of that schedule, but thank you for your work because I appreciate.
Thank you.
Hi, I'm Kate Keppen. I live at 285 North Main. You heard from me in September about my window saga.
Yes.
But first, one of the things I want to ask, so you mentioned something about publicly visible. Most of us in the village live on an alleyway. So literally our entire house is publicly visible. So is there some sort of cap on that or caveat to what can be in our backyards or in around the house if we have certain things outside, so that I don't have people randomly going down my alleyway and reporting nonsense? I have 3 kids. I'm going to do my best, but
Yeah.
you know, I need some realistic guideline on that.
I'm gonna go to Mark on this.
I can just speak right to the draft ordinance. Alleys are not considered to be public ways for the purpose of this ordinance.
Perfect. Thank you. And then my second question, the thing about the windows. So for anyone that doesn't know, my house was built in 1942. I have the old wood and rope and weight windows. It is $7,000 a window to maintain the integrity of those windows. I have 13 windows. I cannot, well, I choose not to take out a loan for $91,000 to replace wood windows. That would be insane, right? So my question is there a cap or a reasonableness estimate on the ROI of my investment versus what I'd have to pay out? Because in that type of situation, you might hate my vinyl windows, but I'm not going to spend $91,000 to put wood back in it. So I need protection as a property owner so that if I'm investing that kind of money in my house, I see that return in my property value. And that's not always going to be the case when it's just aesthetic.
There's a lot of stuff in there to talk about. I mean, and maybe I say that because I may not understand every specific of your situation that you do. My first comment is I'm shocked at that cost. I work, I don't know if I've said this before in the September meeting, but I staffed the Carmel Historic Preservation Commission. And they have a facade grant program that is available to property owners to tap into. I would say I worked with a couple that were considering in their colonial revival house, 2-story, replacing all the windows. I went and met with them. I recommended a firm to them to talk to about rehabbing their 6/6 light wood original 1920s windows. $1,000 a window. So, and they did it with one of our facade grants as well. So it lowered the amount of money that they had to invest. I think they maybe even had more than 13 windows in their house. So I'm not trying to respond to the bid that you got and how good or bad it was.
I don't know how they got that, because even my quote for vinyl windows range from 12 to 20.
Yeah, well, vinyl,
like
you're going to
that.
find vinyl windows
So-
are going to be less expensive than new wood windows.
But that's still more than $1,000 a window, is my point.
Yeah. But
Wait, the
my
vinyls
point,
were more than $1,000 a window?
Absolutely. They
Yeah.
were 3 to 4 a window.
and they are not going to be of the quality of
Oh, I don't
being
disagree
able to
with that
keep
at all.
the original. So anyway, that's going off into a whole nother rabbit hole that we can get into about windows and window rehabilitation. What I want to take away from this more is, and I'll get back to your question about ROI, but I do hope that property owners who are in districts see the commission as a resource that they can come to and say, you know, I'm struggling to deal with this issue just like you are. And, you know, this is what you guys do. You do older buildings, you do historic structures. Can you advise me on what I should do, what the approach should be in dealing with this? Because I don't want to have to spend $91,000 on dealing with my windows. I can't, I can't afford that. So there are clauses in here that relate to economic return on the property that even are tied to potential for demolition. So that's going quite a bit further than just a window project. So I know this is really specific to your situation, but
the windows are just my
is-
example of the
Right.
point. I make 6 figures. I have no debt, and I'm worried that I'm not going to be able to afford to maintain my house if you pass this. I mean, and I think that's a valid concern, especially if somebody can sue me to maintain my house in the way they think I should maintain it. That I'm very concerned I'm going to be priced out of my own home that I've lived in for 12 years and raised kids in. That's my concern. The windows are just a stupid example of why, and how quickly something can add up because somebody can say they don't like my stupid windows.
Well, I would counter that I don't think that this ordinance will do that to you. It will not drive you. out
This
of your
ordinance
home.
will not.
Right. So I mean, you can take me at face value in what I say and dismiss that, of course, but I've been practicing historic preservation for 30 years and have worked with many commissions around the state and have never heard of an example of somebody being, priced out of their property for the reasons that you've outlined. So, Could you say you had an economic argument to make for wanting to take a particular action? I'll take the windows out of it with your property. I would say that you could appear before the commission as part of a certificate of appropriateness application process, just like you're standing here now, and saying, look, this is my situation and I cannot economically, it doesn't make sense for me to do X. I'm proposing to do Y, and I'm hoping that you'll approve that based upon the numbers that I can bring forward. And they're going to be
with all due
reasonable.
respect, without it, I don't have to ask for that right now. If you just leave me alone, I can just repair my windows one at a time, like I have been going through acres and doing it myself. So I don't mean any disrespect on it, but
No,
if there's no
none
ordinance,
taken.
then there's no problem for me.
Well, then
So-
you're a no.
Oh, I'm absolutely a no.
Okay.
Sorry.
Thank you.
Yeah, thank you.
Thank you.
Go anywhere quietly anymore, I guess.
Larry Jones, 4513 Austin Oaks Court, member of the Plan Commission, BZA. I just want to make sure I'm actually hearing this correctly. So the piece we're talking about tonight is the ordinance that allows for the creation of a historic commission, and that individual historic districts will have a set of guidelines based on the area, the type of housing, the location. I've been involved in working with the IHPC for 40 years, Chatham Arch, Fountain Square, Cottage Home, various neighborhoods. If I'm hearing this correctly, I too think everyone's got a legitimate concern when it comes for allowing individual neighbors to seek relief or judgment against other neighbors based on how this is being written. And the case I want to make is that each district is going to have a set of guidelines. An individual is going to appear before the commission with their plans, specs, whatever, to get a certificate of appropriateness. Now, the good thing about a certificate of appropriateness, if it's set up correctly, is it can carry on for years. You may have to do a renewal process, but one of the questions was, if I've got a large amount of work that I want to do over time, am I going to have to come back for every single item? No, you shouldn't have to do that. My core concern is that certificate of appropriateness is going to be generated based on that commission's interpretation of the guidelines and what this individual intends to do. And once they start that work, the way this thing is being written, if a adjoining neighbor, a concerned neighbor, something doesn't like the way the commission has interpreted the guidelines to grant that certificate of appropriateness, that individual can then sue the owner of that property. If anything, that whole paragraph needs to be kind of reworked, because truly, if an individual is upset with how a guideline and a certificate of appropriateness has been issued, the real suit should go back at the commission and not to the individual owner, because the individual owner did everything correctly, getting that certificate of appropriateness, thinks they're headed down the right path. And because somebody else interprets the guidelines differently, they now have been entitled to seek a legal remedy against that individual. And I don't think that's correct. I could go on. I got sued by an individual all the way to the state Supreme Court over a project, but they never sued me. They had to sue the city of Indianapolis and the Indianapolis Historic Preservation Commission. They lost repeatedly. And frankly, it didn't cost me a dime. But if that individual had been able to go after me personally, we'd still probably be having at it. So that's it. Thank you.
Thank you.
Hello, thank you again for your time, and thank you, Joe, for getting back with us today. My name's Ann Hall, 150 North Main Street. So I want to get back to basics a little bit here. I'm not the legal terms, and I don't even want to pretend I know what I'm talking about, but I was under the impression we first got all this information when this first started I live on Main Street, right across from the house that was torn down. And that was the big hullabaloo. Don't tear down these old, beautiful houses, these old historic houses. Don't tear them down. And now it seems like we've added all this other stuff into, we don't want to destroy our historic homes. Is that right? Did this start with just historic homes being torn down?
Well, first I want to go back and understand, are you talking about 145?
Yeah.
Okay, this was done way before.
You started this before that happened?
Oh my gosh, 2.5
Okay.
years ago.
Okay.
Yeah, this had nothing to do with 140. I want to make sure that's very clear.
Okay, all right.
Okay.
Okay. I mean, again, you know, the house was torn down. I thought this whole thing started because houses were being torn down. So how is this different from a homeowners association? How is this historic? And does this new commission district, that if it gets approved, how does it affect every house in the village, every house in this district?
Okay, so first of all, are you talking about this ordinance?
Yes.
This ordinance has nothing to do with anybody at this point.
But it does. You keep saying that it has nothing to do with it, but he's saying, well, he'd approve this just as it is.
No, this ordinance is passed by the town council and is eligible to apply to the town of Zionsville.
Okay. So is it
So
typical
then-
to approve something before we know what it is?
What are you talking about?
Well, you say these aren't the real guidelines. These are just guidelines. This isn't the real. I mean, how can we pass up something that we don't even know what it is?
Well, this is it is, we know, it's establishing a commission.
So we're just establishing a commission, but we don't know what this commission is going to do. We don't have any guidelines for that.
It's all in here.
So it is in here.
Mhm.
So this is it.
Yes, ma'am.
Yeah. but
Okay,
there's-
well, you said this is just a guideline. This doesn't apply to us.
Okay, but this may need to be a one-on-one because I have no idea where this is coming from.
Well, no,
Well,
no,
I think the word that was used earlier.
is
and
the
it's stamped
draft.
On here, it's a
Correct.
draft
Right.
ordinance.
Yeah.
And
Right.
that means that people here and from.
So we
the
can have
public can
input
make
on it.
comments
Yeah,
and
Right,
make
absolutely.
comments.
Right.
Yep,
Okay.
definitely.
I guess I'm confused. Like, if I'm going to vote for something, I need to know what I'm voting for. So this is per se what we're voting for.
Other than a
Even though
couple of
we don't get a
changes
vote.
that people have recommended, I'd like to go back to the lawyer. Absolutely.
Right. I mean, then the homeowners don't get to vote. We just get to talk to our district council member.
What I would suggest is that, as we said earlier, so the commission, this ordinance is passed, it puts the commission in place.
Okay.
It will then look and talk to the community about sort of next step as to, do we look at doing the area that you live in as a potential district for designation?
Mhm.
And if so, if I were you, I would definitely want to have a part in that process.
Right.
Oh, yeah,
So that my
absolutely.
voice
Right.
is heard as to, do I want paint regulated or not? Do I
Mhm.
want, you
And
know?
will homeowners actually get together
Yes.
and have a vote on
Yes.
that? Or is it our district council member?
Right, first of all, this does not say that the whole group has to come and vote on this. So I'll
No.
make sure that's very clear.
Okay,
I know that's been brought up a couple
right,
times. That'll
right.
be up to whoever creates that district. That is not a statute that we have to follow. A guideline, a framework, whatever you want to call it.
Right. Okay. So, and you know, I guess the other thing that concerns me is there aren't very many people here, but I mean, I have a 90-year-old neighbor. I have an 84-year-old neighbor. They're not coming out to this meeting. They also, you know, they can't afford to spend $800 every time they want to, you know, pull out a bush or say the windstorm took down a light. I mean, our new house what houses are involved in this? Like everybody in the town is going to have to go every time they want to change something out, or is it only historical homes?
It's the district, however the ordinance for the district is written.
And we don't know what that is yet because
Nope.
it's not created.
Nope.
Right.
Okay.
Let me just give a quick example. I mentioned earlier that I'm the staff of the Carmel Historic Preservation Commission. So the city of Carmel has 31,000 parcels of land within the city limits of the city of Carmel. I mentioned earlier, one of the earlier steps that a commission does is a survey
Mhm.
of the historic properties within a community. Right now, their survey identifies just over 1,000 of those 31,000 parcels are identified as being historically or architecturally significant. So those would be, that's the limit, the cap that could ever even be eligible to be designated underneath something like this in the city of Carmel. I don't know what those numbers are here in Zionsville because I haven't seen a definitive survey yet, but that's the point, is that we're at the very beginning with this ordinance. And as you walk down the road, more and more information will be gathered and presented, and opportunities for folks here in the community to participate.
I guess, I mean, I'm a little leery. I mean, I'm definitely for saving old houses. Definitely, no doubt about it. You know, I don't want to see that happen. But at the same time, I err on the side. I mean, I don't have a lot of money. I chose to pay for my kids' colleges, their PhDs and their nursing schools and everything else. Therefore, I live in a very tiny house, and I don't want to be a charity case. I don't want to have to go to the commission and say, oh, you know, I can't afford to put in these nice windows.
Sure.
Or I can't afford, I don't want to be a charity case. I don't want to have to go to a commission and say, you know, I've lived in this house and now I can't really afford it because of this commission we've got going on here. You know what I mean? I don't want to have to do that. So it's a little scary to sign off on something that I don't know what I'm signing on. You know, I want to preserve old houses for sure, but the upkeep and, you know, some of the other issues that we don't know yet are hard to sign off on when you don't know what you're signing off on.
Yeah, you're just signing off on a commission right now with guidelines.
I know, but we don't, with these guidelines, and we don't know who those people are that are gonna then.
You wouldn't know, just like pizzazz or.
I'm sorry.
I said we don't know that yet.
Yeah, no,
Right,
no,
yeah.
I mean, you don't know who any of the commissioners are gonna be. I mean,
Exactly.
I'm on the police commission. I have no idea who's gonna be on it next year. You know what I mean? Larry's on a couple of
Right.
commissions. He may
Yeah.
not be next year. I don't know.
Yeah.
Yeah,
But I understand that, and jobs come and go, but our home is our home.
yeah.
You know, we want to stay there. We like where we live. We like our house. We like our neighbors. But I mean, you know, I guess for me right now, it has to be a no until we have more information.
What more information do you need? I'm just curious.
Well, I mean, you're telling me if I want to tear out a bush, I have to pay $800?
No, remember, this is nothing. This is the guideline. This is to create a commission.
But who's to say that that commission isn't going to approve me saying I can't just go buy a light fixture?
The commission is not creating the ordinance. The district, whoever from that district is requesting an ordinance will go to that commission to present what they would like that district to be as far as following that district specific ordinance.
So somebody else is still making the decision for what I can do to my house.
Well, it's not approved. I'm just saying they can.
Right, if it
Anybody,
gets
like,
approved. Right.
This nice lady here, she said, well, what if I just had one farmhouse? Well, that one farmhouse can go to this commission and try to get it approved. If the neighbors don't like it, they can speak up. It's
Yeah.
just like any other ordinance or
Maybe-
petition or commission.
I'm thinking one way of explaining it, which I think everybody probably understands, but this is an enabling the types of things that a historic district could regulate. The commission could regulate in a district, but the district hasn't been established. So what we're reading for, like on page 8, section D, it says criteria for considering effective actions on historic building. And it outlines the historic architectural value, character, compatibility of significant alterations, like the details, materials, elements of style. Those types of things could be regulated by a historic district. So by establishing this, the commission.
Preservation Commission, yep.
Then there'll be a plan for the village. If the village is obviously the main place that will be considered that we're talking about.
Right.
There'll be a plan, and then there will be a decision by the commission about what types of regulations will be enforced. And it could be things like we've talked about windows. There's been a lot of talk about paint colors. There's also been talking, like the last meeting, that the main thing we were talking about was a conservation district, which would primarily affect demolition of structures. So I think in tonight, the message you're hearing that's saying those regulations aren't in front of you. Those regulations are not coming into effect by this action. That's all true, but it's also true that this enabling legislation, let's call it, would permit a district to be established that would regulate those things. Is that correct?
Yes, because it's in this draft.
Yeah. So, and that's what you're saying is, but it could be.
Right,
And I think the answer is yes, it could, right? But that is not what we're considering right now. What we're asking right now is, should a historic district be established? A historic commission
Yes, thank you.
be established?
Yeah.
And then what authority would that commission have? And I think it is true to say that that commission could have the ability to regulate the types of things you're concerned about.
Exactly. Thank you. Thank you.
No, great questions. Thank you.
Hi, my name is John Ho. My parents live at 240 Maple Street. I'm kind of here just to get a better understanding of what exactly we're talking about. And I understand that this is a framework, a guide to what could be set up in terms of a historic district or multiple historic districts. Having been around Zionsville for 45 years now, I've seen this place grow. And it hurts me to see a lot of these old homes torn down because that is the soul of what this town is. Okay, we have good people here, and that's part of it too. But the soul of the town is the village itself. My concern is that if we get too far into this and develop these historic districts, which part of me wants and part of me doesn't, from the standpoint of you have several families in this town that have lived here forever, that are now on fixed incomes, that may not be able to afford to take care of their homes because of fees that they may have to pay to change their house color from gray to white, or to change the landscaping, or to make a small addition. Maybe because some of these older homes only have one bathroom and maybe 3 bedrooms, so they want to do a small addition. Well, how much is that going to cost? How much are they going to have to do in that? So part of what needs to be taken into account here, and I realize that it may not necessarily be part of the framework, but for people to think of when it comes to voting for these historic districts, it's how are we going to be able to price people and keep them in the district as opposed to forcing them out because they no longer are able to afford to live and maintain their home in that district. So is there any way that that can be addressed?
I mean, my only comment to that is I completely agree with you. I mean, I've worked for a nonprofit my entire life. I am not a wealthy person. And, you know, the amount of available funds that somebody has to be able to reinvest in their property should be at the forefront as we think about how we can provide assistance to these folks. Like I said, I work in other communities where what we've been able to do through the commission is set up grant programs that we can make available to property owners to use to offset the costs that they have to invest into maintenance of their properties.
Sure, and that's great and all, but does Zionsville have that set up right now?
I don't know.
Not unless there's something I don't know.
Certainly, the Zionsville has many economic development tools that we utilize. You know, certainly the creation of a facade grant program for residential is not a program that exists right now. Certainly, as the town council contemplates its strategy as to how to fund this program, and certainly what other mechanisms could be created to create a pot of a source to fund exactly what is.
But I just come back to the fact that you have many people that are on very fixed and limited incomes that live within the village itself, that when it comes down to it may not be able to afford to pay an $800 fee for this or a $500 fee for this or whatever fee you decide to set for it. Maybe not you, but whoever sets a historic district. I get it. I had a grandmother who we had to build a ramp for her home for her to be able to get into. You talk about people that would have concern as to whether or not, you know, an individual would sue another neighbor. The only time the family could get together to build that ramp was on Sunday. We had 3 police calls called to that house because we were building a ramp for her on a Sunday. And it violated a noise ordinance or it violated this. You know, so if you don't think that there are people out there that will maliciously go after somebody just because they don't like them or make it difficult for them to do something because they don't like them, look up YouTube. There's plenty of examples of bad neighbors out there. You know, so I think that one thing that we have to consider is, yes, I want to keep the historic portion of this town. It pained me to watch that 145 be tore down on Main Street, you know, but when it comes down to it, what's the town if you don't have the people to make it the historic district that it is? You know, the buildings are part of the soul. The people that made this town is part of its soul. You lose that, what are you left with?
Yeah, I mean, just speaking for myself, I don't disagree with anything you've said.
No.
I think that, you know, both from an economic standpoint of assisting folks who need it for the maintenance of their properties, as well as maybe there is some mechanism. I'm not the one that you said that sets fines or fees in the town, but for people of a certain economic bracket that they have a lesser or maybe no fee at all that they have to pay. I don't know if that's possible, but that's.
And I appreciate that, but the lady that was sitting back here earlier that was talking about her windows, she's right. Absolutely right now, she can pay or not pay whatever she wants to maintain her home. But you put something like this in place, and if my parents can't afford to maintain their home, are they going to get sued by their neighbor? You know, if my parents want to make a change and just go out and paint their house, are they going to get sued because they didn't go out and get a certificate of approval? I mean, those are things that I hope everybody considers when it comes to this kind of thing. There's got to be ways to protect these buildings. I get it, without coming across as basically a homeowners association that says you have to do it our way or else we're going to fine you. So I would encourage somebody to at least look into that and see if there's any other way to do this besides setting up, you know, I guess what feels like kind of draconian types of measures for that kinds of thing. So, but I appreciate what you do, and I appreciate, you know, going forward with this, but I think people really need to question that part of it. So
I also agree with all the comments. I'll just offer some of the perspective I've offered previously, but you know, zoning regulations, individual property rights, and other things like the cost of home maintenance for people on fixed incomes. You know, these things are issues outside of a historic district, right? And they're big issues, and there should be help for people to maintain their homes, and the difference in cost between vinyl windows or replacing wood windows, that's there whether the historic district is there or not. Some people might still want to put in wood windows even though they're more expensive, and as Mark pointed out, there might be many different vendors to get bids from, and it might not be as expensive as it would. And part of the purpose of the historic commission that Mark also mentioned is to help find those resources. So it might actually become cheaper to put wood windows in if you have a historic district, because you'll have a new market for those types of windows. I just wanted to say, you know, the purpose of this is to protect those historic features. So some of the other things that are in place, like the cost to fix your house, whether or not you have bad actors in your community that might sue a neighbor for any issue, you know, those things are there regardless of whether you have a historic district. So I would point everyone just back to the purpose of this ordinance, which would be to permit a historic commission to be formed and to protect the community's historic character and resources.
I just don't want to make it more difficult for one side because of the establishment of something like that. So.
And I acknowledge that a historic commission and these regulations would be new. It would be a new process, but working with historic commissions does not have to be bad. I live in a historic district. I mentioned that at the last meeting. Your historic commission can be a resource, and it can be just as much as a help and a resource for the community as a hindrance. And ultimately, it's about that protection, right? Is the purpose, does the community want to protect these buildings and these features?
That's where I would ask if there's another way to do that besides just the development of a historic district. You know, some of these are older buildings that may be able to be protected based on maybe the fact that they were built in 1850, and it's a historic building as opposed to a historical district.
That's what this would do. The commission would actually give you the right to permit or protect an individual building.
Okay. Thank you.
Thank you.
Thanks, John.
Hi, Doug Noonan, 7032 Beaumont Court. Sorry, I got here late. Wish I was here at the beginning. I tried watching on YouTube. I got a bit confused. I mean, not by YouTube. But I wanted to clarify, so part of it's about the process, but about the document I read. Because what I'm hearing is that this draft is going to set some guidelines for how we would go about creating a historic commission, and then the commission would operate. And when it decides to send a map to the town council would vote, and the map would be accompanied by some description about how we'd regulate it. And I hear things like, but this doesn't affect anybody and won't affect anybody, the draft guidelines, until we see the town council pass something. Except as I read it, that's not in fact the case because of section 6, if nothing else, about the interim protections. So as I read it, the interim protections allow the historic commission to regulate and restrict property use on anything it so designates. And it stays like that indefinitely.
Sorry, I don't mean to
Section 6. I don't know the page numbers.
The whole thing?
Yeah, the whole thing is on interim protection.
Page 6, section 6, interim protection.
That's the one. And some of this it's to a process, maybe to the calendar issues that people have mentioned earlier. But I don't see anything in this about sort of the process in the calendar that stops this from being an indefinite designation by the commission with no actual vote by, well, literally anyone, I think, except if the commission so chooses to vote internally. And that could stay there indefinitely because there's no sunset, there's no clock that says the town council has to act on this map that's been put before them within 30 days or something. It could just sit there, right?
Correct. And yeah, I mean, I'm not.
Okay, mostly it's just clarification. You know?
No, yeah, I mean, I'm not going to tell you something that isn't accurate. I mean, it is such that if the commission were to place a structure under interim protection, it would stay there. Now, the one additional thing that you haven't mentioned is that when you place a structure under interim protection, it must move to designation. So you're not just placing it under interim protection for 5 years, inconveniencing somebody, and then it goes away. You are indeed moving to designation.
Or rejection.
This is, well.
By the town council,
yes,
right.
Yes, exactly. Right. So if a commission places a structure under an interim protection, the times I've seen it used, it's mostly as like an emergency measure, like, oh, this building's gonna get demolished kind of thing. A developer is gonna tear it down, whatever, you can protect it and then kind of work out the details of designation.
And I get the clear intent, and there's lovely evidence, mostly anecdotal, that these kinds of things happen. With the threat of being put into a district leads property owners to do things to their property. So I get the intent behind the interim protection, but as it stands, as I read it, there's no recourse to any public input. There's no vote, there's no town council involved, and there's no time limit on any of that. And it presumably we have no bad actors, so it would never get used in a mischievous way. But I just wanted to clarify that I understand that right. And so when we say that this doesn't actually, passing this ordinance wouldn't do anything to anyone's property, conceivably it could do anything to anyone's property without actually ever instituting a historic district anywhere in Zionsville. One last little one then. I heard stuff about barns and it got me confused that we could put barns in a district. I thought this was just for residential structures.
I think, well, she's not here. I don't want to speak for her, but I think she was talking about she's over there. She was asking about an individual district, if it was like an old farmhouse. that they want to protect? Would that include the barn? Would that include that? That was, I
You know
think
what?
that's on the
I have
question.
to say, I may have misspoke. That may have been my mistake in adding the barn in there. Because it is true, this ordinance does specifically say for residential properties.
Right.
So if and this is where I'm looking at Wayne, I mean, I don't know if a farmstead, meaning the house with the barn or other outbuildings are considered residential, or if it has to tie to the zoning classification, or how you would do that, if it's agriculture versus residential. Yeah.
Thank you, gentlemen.
I think the problem with just vaguely.
We can't hear you yet, so.
I think the problem with vaguely just saying like the barn is people might interpret that for sheds. And maybe you don't want sheds, you know, especially a certain kind. I had a couple of points of clarification. I don't really understand the people who are talking about suing their neighbor. Isn't that a private action? If it were because of a violation of the ordinance that is passed eventually, wouldn't that complaint go to the commission? And then the commission would hear remonstrances. Many times we had our commission hear remonstrances, and that would change then or influence their decision on whether to approve or disapprove a change. Then my other question is, why couldn't there, and I always wanted this, why couldn't there be a sliding scale for the fee so that a person who just wanted a ramp wouldn't pay the whole, say, $800 or whatever you set it as? Their fee might be, because it's a simple question, might only be $100 or some such thing rather than the full 800. And then I never could understand why, if a person wanted to do one repair one year, one repair for the next year, they couldn't get approval for the whole from the beginning.
The project.
Yeah.
Yeah. I think that's what we heard.
Yeah, Larry was saying that.
Gentleman with the crutches.
Yeah,
back
Larry.
there. Sorry.
Yeah, no, that's fine.
Was commenting.
He had a
that-
ski accident.
Oh, okay, lucky him.
Lucky skier.
But that you could bundle it together,
Yeah,
and then the commission could approve a multi-year, you know, COA. So I think that's something that could be looked at here as well in terms of implementation. So to your first question.
Yeah, so the sliding scale,
Yeah,
remember, that's not, correct me if I'm wrong, that won't be dealt in this or any others.
Oh, no.
That's dealt with
no,
your group. Do you do a sliding scale right now? For when anybody's wanting to do an addition or doing a?
Well, certainly the building permit fee structure is based upon the size, partly based upon the square footage of the project underway, minimum permitting fee, a multiplier based upon the square footage. And then we do know how many inspections we'll be doing, and we generally have an idea of what that trip charge, that trip generation is. And so that's how that fee is calculated. So it is, I mean, a sliding scale in that aspect. I mean, a brand new home permit, 5,000 square foot house, that permit's going to be much larger than a 200 square foot addition on the back of an existing home.
Can I do a permit that lasts years?
Our zoning ordinance supports a permit with a life of 1 year and a one-time extension of up to 6 months. So that ultimately results in a permit that could last as long as 18 months. We do have projects from time to time that do not finish within that time period. And what those projects end up doing is receiving a brand new permit.
Do they have to pay again?
Yes, they would. Yes.
And that's what this would follow right now, because it's following your fee structure for the town.
Well, again, get back to the town council's strategy as to how to fund this program. Certainly that you could follow that type of structure in terms of a smaller project has a base fee, a larger project has a fee plus a multiplier, whatever that may be. It's certainly up to you.
how would that get changed? If one wanted to do an extensive project that, like the person who wanted to do windows 1 year, paint the next year, and so forth. Could you change that without full council change in the law for zoning? Maybe I didn't ask that correctly.
Well, if we're talking about the Historic Preservation Commission,
Right,
certainly
and
they could
isn't
structure.
that really the historic preservation? Isn't that where the lawsuit would ever happen? That's not really neighbor to neighbor. That's another issue. The real issue is someone said, I paint my fence green and my neighbor doesn't like it. The complaint would have to go to the commission, correct? And so who would bring suit against the green fence would be the commission. And the lawsuit would work that way rather than the neighbor suing him, unless the neighbor wanted to do it that way. Right? Am I correct in that?
Well, so
No?
again, the question, earlier I said, no one on the panel tonight is an attorney, so I
Right.
really don't want to answer legal questions, but I will say, like I've said many times, the purpose is to protect the
Exactly.
the
It's a
historic
protection
district.
thing. It's not a punitive thing.
Right, and it does say that anyone taking an interested party taking action would be for things done in violation of this ordinance. So you must be found to violate the ordinance.
And that would go to the commission.
That's not my read, but I might not be seeing a section. My read is that it could go to court. It could go to the circuit court, but it's
And bypass the commission? Yes.
that is my read of the section that I'm looking at right now. But it would have to be an action or a suit brought in violation of this ordinance. So a judge would have to determine that the violation occurred. And that's my key point on this issue, is that if you are acting within the rules, the established rules of this ordinance, the court will find in your favor. And that's the whole purpose of these types of suits, is that you must be found guilty, right?
Right.
So, you might be asked to come up.
Yeah, just because this is recorded.
Sure. And this is,
Can we both be up here?
Sure.
as long as you're okay.
Okay.
And I think that's what this gentleman who was sitting here had an issue with earlier, was the fact that if it does go to court and we've done everything right, then the judge would find in our favor, correct? Okay, but I am now out litigation fees that I cannot get compensated from the person who took me to court based on how that language is written.
Yeah, that's.
Yeah, and that note was taken.
I got that.
Yeah.
That's going to the
That would be a
lawyers.
star.
Yeah, that's my biggest.
So, and I
Star.
think that's what a lot of people are more interested in. The fact is, if there's something like that, that does need to come back to a council before it ever has to go to court. Because I don't think I should have to defend myself in court if I've done everything right based on what you guys have written,
Exactly.
until you guys say, no, you did it wrong, and then they can take me to court for it, or unless I remedy it.
If they got commission approval for something, the green fence, then how does that person get to sue the neighbor when it's already been approved? Or do you just still leave that in the hands of the judge?
Well, yeah, somebody's attorney would have to say, did you get approval for this?
Yeah.
And then their attorney would have to take the case. I mean, right?
Yeah.
And then
But
the
you
judge
have to
would,
go through your attorney to do that.
yeah, I mean, you'd have to have somebody
you could do
feel
that.
like
You
a
could-
violation occurred.
But you could do that today without this. I mean, you can get sued because someone's lawnmower's been sitting there for
That's my
3
point.
months.
If we do adopt this ordinance in whatever form, changes or not, then things need to go through that first. And then the person trying to sue wouldn't really have much of a leg to stand on.
Mark, what do they do at other locations?
So I just want to say, I think it's both. Okay, to the point, the questions you're asking, the way the ordinance is currently written. So a property owner has the right to sue another property owner.
Sure. But not-
Because they may not like something they've done and they feel that it violates
Right.
the ordinance.
Right.
If somebody wants to spend that money and take the risk that they may lose in a court of law, then I guess that's their right to do that. We live in a litigious society, and people sue each other all the time for reasons I don't understand, but it happens. Under the town of Zionsville, the commission, of course, has the ability to see a violation, and as a result, that party can, the commission can sue that party for that violation. And that's why this is all spelled out under both the enforcement by interested parties as well as judicial review as to what steps are taken by both sides of this issue.
No, I understand. I just don't understand when the lawsuit would come from an actual neighbor or when that lawsuit would go through Zionsville or the commission. That was my question, I guess.
The commission is the final decision for the town on certificate of appropriateness.
Guidelines.
After the commission's decision is made, it goes to judicial review. That's my read, right? So it's the commission's charge to grant certificates of appropriateness, right?
Right. I think that helps. Thank you.
I'm hoping that Mr. Hall's recommendation, or the gentleman that was sitting here before, of making sure that verbiage is the attorney fees would be paid either way, should eliminate some of this angst of that part, right? I mean, I agree. I mean, it'd be hard to go in front of the town. I'm getting text from Brad Burke that it'd be hard to even read this without looking at that fee structure for sure. So yes.
Just a quick comment. I won't say this won't happen, but we're kind of fixated on green fences and bushes being pulled out of your yard. I don't think when this started like 2.5 years ago, that was our main focus. And it may happen because this is just a draft, but overall, I don't think that's where we're really trying to, get nitpicky with people and things like that. So again, I know all the paint and all those things, the HOA things that people are worried about, it's a possibility. But I think in the scheme of things, I don't think there's too many people, and all the support that I've listened to in the last 2.5 years, that's really not our focus. That's not really what we're trying to push for here.
Yeah, I think the point that I read is we got to make sure this is right so it doesn't get abused by someone who tries to create a district that, I think there's a lot of rights on both sides, right? I mean, I think both we need it. And before we leave, I would like Mr. Hall to come up here in a second, but yeah, I think that this is the opportunity to make sure that this is structured so that it doesn't get abused by another potential district. Or if I go to Hawaii and retire, that someone doesn't mess this up. Well, I'd love to go to Hawaii and retire. But I think they're very valid points. I think that anybody could sue anybody for anything. You know what I mean? It's like the guy's lawnmower's been sitting out there for 3 years, So I think these are all very valid. I would like, are there any more questions? Otherwise, I'd like Mr. Hall to come up real quick. Can you pull up that page 2G interested parties for me? Because I've read through this. I know it's kind of hard to read through these when people are asking such good questions, but I've read through this a bunch of times. I don't know. I'm guessing I'm missing something. Which of the 7 are you recommending should be taken off here?
All but number 2. That's what I was discussing earlier. Is if the town council wants to take me to court due to a large violation, so be it. But I don't know that any of the other folks on here should be able to take you to court.
Okay, so I'll get even more specific because there's always negotiations on all this, trying to figure out what works and doesn't.
Yeah.
Where is it saying that anybody can sue me in those interested parties? Can someone tell me that?
Yeah, it's 4.
It just says a neighborhood association, whether incorporated or unincorporated, majority of whose members are residents of a historic district designed by an ordinance adopted by the town council. So I read that as anybody in that district. I'm not reading that as someone from Thornhill driving through the village is part of an interested party. So I'm a little confused.
So I don't have that highlight here. Let me get it and I'll send that to you in email.
Okay.
But section 14 talks about interested parties as defined in section 2.
Hold on, let me get to it. Let me get to it real
I'm
quick.
sorry, page 13.
Yeah, you're fine. Lots of pages and lots of notes.
Yeah.
Okay, which
All right,
one are we
A,
doing here?
Interested party, as defined in section 2, as a private right of action to enforce and prevent violations. So again, it goes back to anybody, any of these interested parties. can take-
In that district. There's nothing in there that says an individual from outside that district, correct? I'm only asking this to clarification because I'm going to go back to the lawyers. I'm going to look at this.
The one that I had originally, I left at home. So let me go back and find that. And I'll
I'm just
email it
asking
to
for
you.
help. You know?
Yeah.
Because
That's fine.
I don't see where it says any individual outside of that
Yeah.
district.
It's in here someplace. I've got
I'll
to find
just
it.
point out that section 2G, that is what's in state enabling legislation, except it says mayor of the town of Zionsville instead of mayor of the city of Indianapolis. So these sections are all the same.
Yeah.
Let me find that
This
for
is
you.
just a template.
And I'll
that
email
we're-
Well, just a lot of people, I just don't want people that have been watching us sitting outside going, oh, you mean anybody can come sue me? Well, that's not what, I don't see that where that says it.
Yeah. And so I could be wrong. Let me go back and find it. I've got a circle at home. I left it on the kitchen table.
Oh, no
Wrong
problem.
Copy.
Trust
So-
me, I got lots of notes to go back.
Yeah.
and look at. And I appreciate everything.
Yeah.
And again, it's kind of hard because we're looking in the rear view mirror a little bit here because all of us have been so entrenched on this for 2.5 years. We're like, okay. But yeah, I just wanted someone to show me where it says any individual outside of a specific that lives outside of specific district can tell you that you're not meeting this.
Fair question. And
piece.
I'll have to email it.
Because that's been brought up like
50%
50% of the questions tonight.
Yeah.
I think the question was 5, which is owner or occupant, but it does say under G5, owner or occupant, but it does say in a historic district.
Yeah, so if I own a rental property in that historical district, I would have the ability to.
Right. Which is,
No, that's, yeah.
So that particular point could mean Hunt Club, someone from Hunt Club could come back. Again, I have no right to comment on Hunt Club. I think they have no right to comment in my district either.
So you're saying an A to the ma'am on the phone there? Are you recommending that an A to a the?
Yeah.
Yeah, oh, I like that. That's what I'm here for. Yeah, I still.
And I'll still look for that other.
And we got that comment earlier, and I remember we looked at that and we said, oh, it says A, so would we want someone from this district to have be an interesting party in the other district? And we kind of everybody thought no, and I actually think it would be.
So Mark, where would that, like, okay, I'm just throwing it out there. So if I live in Indianapolis and there's how many districts? 12, conservation / historic, whatever it is. And I live on the north side and I go down to a historical district in, anywhere in the, Fountain Square. And I see someone's got something that violates the district's ordinance. Can I complain and sue them?
I don't know. I'd say, don't you have anything better to do with your time? I mean,
Well, that's what everybody's worried about, right?
I really, I don't know. I mean, I don't oppose the change from to the. I mean, if that makes people feel more comfortable, it just means you're limiting the pool of people who are going to sue you to your neighbors. And is that a good thing?
Hold on. Can you guys
Well,
can you guys come up here if you talk?
I'm in a district in a different state, and I'm a district there, I'm still able to.
Or a district, you mean a district?
Right. So.
Well, that's the problem. The only.
That's fine.
Yeah.
My point is, you're still, if you're a district of 100 buildings, it's then what you're saying is that another person within that 100 building district can sue you for having done something that violates the ordinance, that for some reason the town did not take that action. And you know, if I've heard people stand up here tonight and say, well, neighbors are going to be pitched against neighbors in this lawsuit situation, and that doesn't resolve that. It's still a potential that could be the case. And then again, maybe a neighbor wants that opportunity, that they hear and the guy across the street is going to tear down his 1850 historic property and didn't go through the COA process. So, you know, if that's what they want to spend their time and money on, I suppose they can if they're in the same district and we change that language. I'm not opposed to changing it. I'm not 100% sure it addresses everybody's concern that's been up here tonight. So.
But I think what we're saying is.
Okay, hold on, sir, because this is being recorded. You have great questions. I'd like for everybody to hear it. Sorry.
I live right next to him. He does bite, so I'm gonna move away. I'll email it.
It looks pretty scary.
I think from my perspective, what we're wanting to do is the wording needs to protect the property owners, not make them exposed. By saying that anybody could sue me as a property owner, that puts me at risk. And we already heard a couple of examples of I don't want to make any changes until I understand what my exposure is. Right now, your exposure is wide open. And if it's the district or the specific Zionsville district, at least then it's my neighbors, which, yeah, they might be. But to your point, who would want to do that? It doesn't matter who wants to do that. I'm exposed and have to pay for that or defend myself for not potentially having done anything wrong. So the wording needs to protect me so that I'll want to.
So to your point, I mean, I already agreed for the lady in the corner back there that said, hey, we want it to be the same. And I said,
I like
that's
that.
okay, let's do the same. Does that address?
You're the middleman.
That's definitely an improvement. It takes the pool of litigations down to
whatever
potentially my neighbors
is,
instead of somebody that's looking for a fight.
Right. And I'm just wanting to make sure we're listening and hearing what you're saying, and we're acknowledging that. So
yeah, I don't want to be here to solution it for everybody right now, but I think maybe some kind of arbitration or solutioning with, it has to go through the board instead of I can just file a lawsuit and all of a sudden I've got attorney's fees and time involved, and because somebody thinks I didn't cross the right T or not the right I.
And I think that attorney fees going both ways is going to solve that problem.
Well, in normal litigation, I'm not an attorney, but in normal litigation, bring a frivolous lawsuit, you're exposed to 3% or 3 times the cost of the other person's attorney. But what this documentation is saying is, if you think they violated a term and you're interested, file a lawsuit, and I'm protected.
Yeah, and I think this could also, I mean, it doesn't, anybody could do that. you know what I mean? So that's what I'm saying.
Yeah, let's word it so it's not encouraging.
Is everybody okay with the?
Let me ask a question of this crowd that we're hearing from. So what if Joe goes back and talks to an attorney, an actual attorney, and they say that striking number 5 altogether, where there's no reference to legal action by your neighbors or anybody in any other district for that matter, but the others remain intact. So the town still has the ability to take action if there's some outright violation that there's an outcry in the community about, that they can still do that. But it removes the whole concern about fellow property owners taking that action.
I don't think they're trying to remove it. They're trying to keep it within the district that is.
I'm taking it one step further.
Yeah, I think we're the fair mark fill out fees.
I mean,
The goal was to
remove it, that the neighbors not be responsible.
Yeah,
This is like 70% of what we've heard about tonight. Isn't that, oh, we're opposed to the preservation ordinance? It's that it's the legal.
Yeah, the
you know,
legal, it's all
I'm
the
gonna get
legals,
sued over this somehow. And I think if we just take that off the table and leave in the other, because I'm sorry, but there has to be interested parties involved because people are interested. You're here. And there has to be enforcement to be able to be
Someone
taken.
can still sue you. You can't just take, so I don't think there's a problem taking that out. Because they can always sue. There's always one. So taking that out.
Yeah,
But I'm just wanting to feel the room. Do people generally feel like that's okay, or are there concerns?
You might need to also take out 4 under the same logic. Because
Well, we're not changing other parts of this.
no,
I'm just saying.
the unincorporated or incorporated neighborhood associations that are in or not in the same district, the one immediately above it, seems like you could just get together with another one of your neighbors and declare yourself a neighborhood association and still have the same standing. So I'm just saying, by the same logic, you might want to strike 5. You might need to go after 4 too.
I'm not suggesting striking 5, just so you know.
Yeah, I'm not recommending, I'm saying.
Yeah, I'm recommending what was just recommended, the same historical district. Okay? That is gonna be my recommendation. If people want to come back, well, maybe someone has a better selling point. But then if someone wants to come back to the first reading or the second reading, more than welcome to. I'm just taking your recommendations, and I think that the same historical district makes complete sense. And I could talk to attorney about 4. We'll see. And you're on the district, you're on the commission too, when it's all done. Yes.
Chelsea Overbeck, 240 North Main Street. I don't have any questions about the attorneys. I think the only thing this has shown me so far is that we live in a town with a lot of lawyers. So that's great. I do have a couple of questions just regarding this specific ordinance and a few things that have been said that I want to clarify as things have changed since the September meeting. One of the things I keep hearing is if we get a district, and I understand you can't answer specific anything for a district since nobody is yet making said district. But one of the things is if the village gets a district and I have to come to you for my historic home to change windows, I think when we started this, nobody in the village said, I want a historic preservation district for the village. They said, I want a conservation district for the village, which my understanding was it focused on demolition, moving a home, new construction, and one other thing I'm forgetting. What is the?
Those are the 3.
There's 3, okay. I just want to make sure that we as the village still have that opportunity with this ordinance, that if we decide to come together as a group of people from the village to say, I don't want to regulate what type of windows I put into my existing home, we don't have to follow that path.
Correct.
We don't have to be subject to those costs and those fees if we don't choose to be. So we can say we want to protect historic houses by only focusing on demolition of historic homes and new construction on these historic lots. Is that still something we can do? Has that been changed, modified in any way?
Nope.
No, ma'am.
It's in here. Just
Okay.
that way. You have it's sort of, it's called a conservation district, as you referred to. It's just those 3 things. If that's all any particular district wants to do, that's all they have to do. If you want the fuller historic district that also reviews alterations to the exterior of the structure, then you can include that as well. Neither review anything on the interior. So nobody's going to ever say, plumbing, do I have to get approval for that? Or what paint color I paint my walls on the interior of my home. So nothing on the inside.
Okay, so for example, if I have an 1880s contributing home currently in the village, and I want to change my siding or paint it or replace my windows, if this were a conservation district, as you called it, for our district, we would never have to come to you for approval?
Correct.
Okay,
You
we
just
would never
go
have to
get-
pay fees.
Well, your building contractor, I'm assuming, would
Right,
get a
permitting
permit
fees.
for that.
If they're
normally to do
needed,
that
but we wouldn't
work.
need to pay the
Right.
certificate of appropriate. So this would not be cumbersome to us in any way as existing property owners of historic houses in the village if we do a conservation district,
Right.
which we still have the opportunity to do. That's what I wanted to make sure. I think my second question was, if I own a house in the village that is not historic and I want to make those same changes, just to clarify, same thing. I don't need to come to ask for any approval. I don't need to pay any fees unless I'm going to completely tear my house down and build a new one. That's the only time I would come to this commission.
You're in a conservation district?
Yes, in a conservation
Yeah,
district.
or if you were doing like an addition to the structure.
Okay.
But then you would, but otherwise no.
Okay. And so for us as the village, if we don't want a preservation district, if we don't want to pay fees for our historic houses, because we don't want to be priced out of them, then we need to work to make sure that our district is a conservation district. Is there anything in particular we would need to do besides just attend the next, so we get a commission, we're going to do step one, and then we come back and we work on our ordinance publicly.
You can do that.
Same
Okay.
process.
And it will be open to the public. We will be able to come in and spend our time with you guys. Like, okay.
Absolutely.
I just want to make sure we can still follow that path.
Yep.
That feels good
It's
to me.
all in here.
Thank you.
John, you start,
West Pine Street.
John, you started us. Are you going to be the last one here?
I'll try to make this quick. I'm a lawyer. I've been one since 1976. I have never sued my neighbor. I have no intention of suing my neighbor. And frankly, I couldn't afford myself if I did sue my neighbor. I know that if I went to court, that courts accord administrative actions the highest respect. They generally do not second guess them. So as a practical matter, I'm not going to take a case where I have the Board of Zoning Appeals or someone else has made a clear decision that's founded upon the law. Judge is going to laugh me out of the court and maybe hit me with sanctions. I'm not going to take a pro bono case unless there's something really egregious. So I don't walk into court just because I enjoy it. I don't walk into court so a judge can beat me over the head along with the other attorney. So I know, and attorneys are responsible for this as well, that there is a feeling that anybody can sue anybody. Well, constitutionally, that's correct. But as far as doing it, that's a big step. I turn down more cases than I take on. I turn down good cases because of the practicalities. I don't want my client to be madder at me than they are at the other person. So this whole thing about people suing each other at the drop of a dime, if you want to do away with lawsuits, don't ever get divorced. They're a majority. Don't ever commit a crime. Do that and you can shut down practically all the courts. Because people are not going into court and suing each other at the drop of a hat. Thank you.
Just for fun. Just for fun.
You want the ribbon for most of
I do,
right?
I do. I had 94 windows.
Oh, wow. That's a lot of windows. That's a record.
Well, I do want to say thank you to everybody. I think there's a lot of great feedback. Definitely the three big ones we'll talk about, and be sure to be on the lookout for that to be put up before the 21st, not the 20th, but before the 21st. And even if it is like the 19th, it's just the first reading. No one's voting the first time. Okay, so I think the three of us, and we just need to get back in the room probably this week or next and hammer this out, because otherwise I think it's pretty clear cut. And I think I keep on picking on Mr. Hall, but you are right. You can't go back, right? So once this is approved, it's hard to go back. And I also I know they don't do this anywhere else, but I got to think how we write this, but you're right. So someone could just say, okay, that we're just going to create this district and copy this exactly how it is. And they could, but that has to be approved by a lot of people. You know what I mean? So they may not let me put that wording in there that you're asking for, Mr. Hall, but I do see your point. And it's, you know, it's, there were a lot of good points tonight. I think they're all doable. I think they're all, not all, but I think it's doable. I think definitely the section 5 with the same historical is pretty big. I think that's probably smart to do, but you know, I'm not an attorney. We'll have to see what they say. But I think, thank you everybody for your time. I know this, you know, this, you know, meant a lot to you guys. It means a lot to me. And I really appreciate everybody coming out. And I would encourage you, the gentleman already left, but that wants to know when he can talk in front of folks, but you definitely have the ability to do that in the first reading, second reading. So, and you know, also please email me. You know, I think Mr. Hall emailed me 2 days ago, and I emailed him right back within 24 hours. Yeah, so I remember at the end of the day, I had a group of folks that came to me that said they wanted this, and it's my job, and that's in my district, or at least half is in my district. So I'm just trying to give them the platform and the ability to move forward with that request, just like anybody else. And I would hope that any of your other council people would do the same for you in outside of those districts. So you know how to get a hold of me. You know where I am. I've lived here all my life. I've known John my whole life, and the Stacys I've known my whole life. I think I've known John my whole life, but I can't remember how we crossed. And so, and I meet some of you in weird airports in the middle of the night and lose your kids. So I'm entrenched into this community just as much as everybody else. So again, I want to, Mark left and Chelsea's here, but a lot of good help, a lot of people putting a lot of time into this, including the 4 of us sitting right here. And you know, we're you know, we're not getting paid to come up here and fight for this. We're doing it because, you know, someone asked us to do it that had put a lot of due diligence into it and time. And you know, I think, in my opinion, I have enough information here to at least get us to a new draft of this, you know, this preservation commission, and then we can see how it goes with the first reading. And I would encourage all of you to feel free to come talk at that time. So go talk to your, let's see. So if you're in the village and you're south of 6th Street, Josh Garrett would be your councilman. We also have, and Brad Burke has been fantastic. He's actually an at-large, so he would be another person if you have any questions or concerns about this. You could also talk to Alex Choi, Dr. Choi. He's also at-large. So we're 4 of the 7 folks. I would think that if you get a chance to talk to the 4 of us with any big concerns like that, that would be another way to communicate with us if you'd like. And we'll get back to you as soon as we can. But yeah, really good conversation tonight. I really appreciate everybody's time. This will be the last town hall meeting we have over this. Let's give it a chance. Let's take it to the first reading with hopefully some of these recommendations put in here and see where we go from there. That's the best I can do. So I appreciate it. Thank you everybody for your time tonight. And 94 windows, is that what she said? 94 windows. Yeah.
Thank you.
By the way, I'm going to start selling windows tomorrow, just so you know. Ooh, yeah. All right. Thanks, everybody.